For judgment, item number 1, CRLA 587 of 2016.
So the appellant is acquitted, granting him the benefit of doubt. The appeal is allowed.
For judgment, item number 2, WPC 19306 of 2018 and 2757 of 2017.
The writ petitions are dismissed.
Supplementary list old matter item number 3.
None appears dismissal on prosecution.
Supplementary list old matter item number 4.
Okay, none appears dismissal on prosecution.
Item number 5.
Mr. Samir Mishra is there? No, item 3 was also.
Madam, just as they unmuted me, madam, I'm sorry. I was trying to
Item
unmute.
3.
I even telephoned to the helpline also.
Right.
Madam, I'm sorry, madam. I'll only say one thing. Madam, this was with regard to a road. We said that it is not as per the approved plan. In the counter, they have said that they have completed it. Right. Wrongly, they have completed it.
All
So
right.
we also
It's
claim-
infractuous. All right.
I pray only your lordship may grant a liberty, because we may claim as per approved plan that should be also another road. That was only liberty I pray for, madam.
Liberty for what, sir?
They have carried out. That is what in paragraph 3 they say. But this is the approved plan. That is the difficulty, madam.
But it's all right. You see, on account of subsequent developments, the petition has become infractuous and it's disposed of as such. All right.
I only request, my lord, the operator should allow unmute, because at times we are getting desperate, my lord, to connect. My
That's a
lord.
different issue altogether, sir. That's a different issue.
No, I'm only.
No. Acha, the unmuting. Oh, I see. All right. No. We'll
We are getting,
make sure that. We'll make sure.
when it is first item, little anxiety is
All right.
obliged, man.
All
Obliged.
right.
Lordship, item number 4, Lordship. Lordship, the matter has become infructuous, Lordship.
Infructuous disposed. All right.
Item number 5.
May I please, your Lordship, my lord? In this case, I am for the appellant, and notice is good, and respondent number 3 has also appeared. But in last order, your Lordship has directed to file counter within 2 weeks, but counter has not been filed,
Tell us what the matter is about.
my lord. My lord, in this case, I challenge the order of the single bench order, that is Annexure 7, starting from page 24 to 28. And your Lordship kindly see 7, that is last para. Having gone through the report of the CDPO Sonpur and other materials on record, it has been observed by the Additional District Magistrate Subarnapur that Majhimunda Anganwadi Center area comprises of village Majhimunda as well as village Chaurasipur. Learned counsel for the petitioner has not produced any material to indicate that Chaurasipur village is not included in the service area of Majhimunda Anganwadi Center. My lord, the case is that in this order, initially the opposite party make public notice for engagement of Anganwadi worker in respect of Majhimunda Anganwadi Center only. But accordingly, the appellant applied for the said center and provisionally selected, and thereafter certificate verification was made. At that time, the respondent number 3 filed a prefer appeal pursuant to the order of the Honorable High Court, and after the CDPO submit the record in the letter that Chaurasipur also included in the Majhimunda Anganwadi Center. And thereafter, even though the appellant was selected provisionally and certificate verification was made, she was deprived from getting engagement in the post of Anganwadi worker in respect of Majhimunda Anganwadi Center, only for the reason that the village Chaurasipur was taken in the Majhimunda Anganwadi Center.
No. Why did you lose your selection? On what ground were you unseated?
My lord, your lordship kindly see page advertisement page.
Sir, why don't you tell us the reason? Why did she challenge your appointment, correct?
My lord.
On what ground did she challenge your appointment?
She challenged that the Anganwadi service area is the respondent is coming under the Majhimunda Anganwadi Center. Even though
you were selected, why were you thrown out?
My lord, only Majhimunda Anganwadi, if the Majhimunda Anganwadi Center is coming this area, then the petitioner was selected. But the respondent number 3 challenged that no, she is the resident of Chaurasipur village. She is the outsider, and she has said that no.
You are a resident of Chaurasipur.
No, I am a resident of Majimunda Anganwadi Center.
Then why are you losing your seat, sir? You are not telling us on what ground did you challenge your appointment?
My lord, because she was her application was included in the.
No. So what? So what? If her application included, why would you?
And she has secured more marks than me.
That you are not saying, sir. For last 10 minutes, we are asking you.
Pardon, my lord, pardon.
Pardon, you are saying so casually. So she got more marks than you.
My lord.
Why haven't you said that?
But in fact, the Anganwadi service.
You are not telling the main point. That's why you are not clear in your case.
My lord.
She got more than you.
My lord. But if the village Chaurasipur has is not included in the Anganwadi service area.
What is there for you to show? You had to show the single judge that Chaurasipur is not part of this Majimunda. What have you said? What have you shown there? What is the material to show that Chaurasipur is not part of Majimunda?
My lord, kindly see, I have filed the additional affidavit at flag A that has at page clearly shows that Chaurasipur has not been tagged in the Majimunda Anganwadi Center.
What have you said in that affidavit?
My additional affidavit, flag A, page, kindly see page 6, the list of the Anganwadi Center area and tagged village at serial number 107.
No, it simply says Majimunda.
Simply said Majimunda. This last column, your lordship, kindly see name of the tagged village. Chaurasipur tagged village has not been included.
That is not a conclusive proof of that.
But my lord, in fact, this document I have obtained after filing this appeal.
No, but this is not conclusive of whether Chaurasipur is part of Majimunda or not. How can this document be proof of that? This is just some proposal for opening new AWCs.
Yes.
This is not conclusive of whether the village is part of the center
the
or
name
not.
of the Anganwadi Center.
You say the learned single judge declined to interfere with the order of the ADM, whereby respondent number 3, the appeal of respondent number 3 was allowed. And the present appellant had to make way for respondent number 3 as Anganwadi worker of the Majimunda Anganwadi Center. Admittedly, respondent number 3 scored more marks than the appellant, but had been rejected on the ground that she was resident of village Chaurasipur, which was thought not to be part of the Majimunda AWC paragraph. As it transpires, the said village was in fact part of the AWC area, and therefore the appeal filed by respondent number 3 was allowed. Paragraph. The learned single judge has noted that the appellant was not able to produce any material to show that Chaurasipur village is not part of the Majipur AWC area. Full stop. Even before this, the appellant is not able to produce any material as such. Full stop. What the appellant has filed is an additional affidavit enclosing a proposal prepared for opening of new AWCs, where according to him at serial number 107, the Majimunda AWC is mentioned, and in the last column, certain villages other than village Chaurasipur have been mentioned. Is obviously not conclusive of the villages that form part of the AWC of Majimunda. as this is simply an internal document setting out proposals for opening of AWCs. Full stop. In the absence of any material to show that Chaurasipur village is not part of the Majimunda AWC area, court finds no reason to interfere with the impugned order of the learned single judge. There is no merit in this appeal and it is dismissed as such.
Supplementary list item number 6.
Item 6, my lord, there is no instruction.
No instructions dismissed.
Item number 7.
None appears.
Item number 8.
This appeal is against the order of the Honorable Single Judge passed in this case number 195/13. The background is like this, my lord. The petitioner was working as a KN development assistant. He was illegally terminated from service. That matter was taken through the labor commissioner, National Labor Commissioner. It was taken to the labor court. Labor court illegally held his termination to be legal. Against that, he preferred writ application.
How is a writ appeal maintainable, sir?
My lord, that is why I am coming, my lord. In the writ application, in the judgment, your lordship may kindly see the judgment. It was clearly held by the Honorable Single Judge that the termination was illegal and not justified. And only towards the question, on the question of reinstatement, the Honorable Single Judge said that since he has approached the age of retirement, so instead of reinstatement, he will give him a compensation of 60,000. And so far as back wages is concerned, back wages was also kept. So the order was that to pay the back wages and 60,000 in lieu of reinstatement. But the management, my lord, wrongly interpreting that order, has paid me total 60,000. For a clarification, I made an application. This miscase, I filed for a clarification from the Honorable Single Judge that this way the matter is being misinterpreted. So let there be a clarification. My question was not touched and the miscase was disposed of, saying that since I have not passed any, since this court has not expressed any opinion regarding the certificate proceeding, in case the same is pending, in such event, the said proceedings shall come to its logical end in accordance with law. This much was said. On the question which I raised, my lord, that was not my grievance was that let that clarification be made so that instead of reinstatement, it was 60,000, and for back wages was to be paid. It was in the order, my lord. If the order passed in the writ application is before your lordship, my lord, I'll take your lordship's to
Sir,
page.
do you want me to repeat the question or you have understood the question that we asked you? You have forgotten what the question is.
My lord,
You don't remember what the question is?
no, against what order the writ appeal is there, my lord?
Sorry, sir. I asked you a simple question. How is this writ appeal maintainable?
Because it is against the order passed by the Honorable Single Judge
In under what jurisdiction, sir?
in the miscellaneous jurisdiction,
227.
my lord.
So no writ appeal is maintainable, sir.
And so
This is what we've been asking you for the last. The first question was this.
it's a question of clarification only, my lord. Otherwise,
Whatever, sir.
the person who has been held to have been illegally retrenched.
The impugned order of the learned single judge is passed in exercise of the jurisdiction exercised in exercise of jurisdiction under Article 227 of the Constitution. Consequently, the writ appeal is not maintainable as such, leaving it open to the appellant to seek other appropriate remedies in accordance with law. The appeal is disposed of.
Item number 9.
Item number 9, there is no instruction.
No instructions dismissed.
Item number 10.
May I please? In the present appeal, the order by annexes 7 and 8 passed by the learned single judge is under challenge, your lordship. But the fact of the case is that the petitioner is appointed by the management under the beyond the yardstick as a fourth peon, my lordship. But then the petitioner filed a writ petition before the learned single judge, honorable single judge, that praying for the arrear salary. After the Daftari has been promoted to the post of Daftari, he has been adjusted by the management in the year 2003. Subsequently, the post has been approved in the 2006. Now the writ petition has been filed claiming the arrear salary with effect from 2003, which is not permissible under law. The Honorable Single Judge passed the order by the annexer 2, Your Lordship, only directing the authority to consider the representation. Running page 32, annexer 2. That while the order passed by the Honorable Single Judge not complied in the due time, he has preferred another miscase for implementation of the order. But then, by the annexer 4, the Honorable Judge passed the order directing the Director of Secondary Education appear in person before the Honorable Court on 29 September 2014 and show cause as to why the contempt proceedings shall not be initiated against the so-and-so person. But thereafter, we have complied. The next annexer 5, the order dated 26/8/2014, the compliance order is annexed, where the authority has been complied with the order and saying that the salary claimed by the petitioner so for a period of 2003 to 2005 is not permissible, accordingly rejected. But the annexer 6, the compliance filed. But after compliance have been filed, now the annexer 7 order has been passed running page 28. The personal appearance of the Director of Secondary Education is dispensed with. However, there is no bar to release the arrear salary of the petitioner in view of the decision of the apex court. But where there is no such order, so far the first order passed by the Honorable Court regarding payment of arrear salaries.
You have not complied with, or you have complied with the order?
Yes, we have already complied. Despite compliance, the order has complied.
The order that you have challenged, have you complied with that order or not?
We have complied.
Then?
Thereafter, the order has been passed.
Sir, the order that has been passed, which you have challenged, that order have you complied with?
Yes, we have complied. The impugned order passed by the annexer 2, Your Lordship, we have complied.
Then why are you challenging? If you have complied with the order, why are you challenging it?
Now, after the compliance, if the person agreed, he has to challenge it. Instead of challenging that, he filed an implementation of order.
Sir, I don't think you have understood the question at all. Have you understood the question?
My Lord.
Have you understood the question, sir?
Yes.
What is the question I'm asking you?
Whether the order passed by the Honorable Single Judge has been complied in the
No. Whether the order that you have challenged, which is the order you have challenged in this writ appeal?
Annexer 7. Running page 48.
Are you challenging only this order, or you are challenging two orders?
2 orders. Annexer 9. Then Annexer 9.
Have you complied with Annexer 9?
But it's not necessary to comply because as per the direction of the Honorable Single Judge, we have already filed the compliance affidavit and complied with that order.
Then why are you challenging this?
Well, subsequently, they have insisted upon to pay the arrear salary.
Have you paid or not?
It is not necessary to pay because in view of the Honorable Apex Court
anyway, then this is how you are going to argue. Then you have taken upon yourself that you don't have to comply with anything, correct? You yourself that you don't have to comply with anything.
We have complied.
Sir, if you have complied, you don't have to challenge.
But the direction was to consider the representation. We have considered the representation and
if you have done everything, why are you challenging? Why are you wasting the time of the court?
But then the annexer 9, the Honorable Court said that put up this matter on 24th for compliance of the order dated 1.
Sir, has he filed any contempt? Has the other side filed any contempt?
No contempt.
Then why are you wasting the time of the court?
That's why you prayed before.
Counsel for the appellate insists that all the orders of the learned single judge have been complied with. And he says no contempt has also been filed by the opposite party or by the respondent. He's unable to explain why the present appeal has been filed. The court is also unable to understand why the appellant has challenged the impugned orders if it has already complied with them. The appeal is accordingly dismissed.
We simply pray your lordship can hold that we have complied. That's the
item number.
That is the sole prayer. We have complied.
So someday what you have arguing, you will probably understand Neither of us has been able to understand anything that you have said. All right.
Item 11.
Yes.
Item number 11, my
Item
lord.
number 11.
Yes.
My lord, 1 week time may be given for removal of.
No. This is a 2014 matter. Please tell us what it is about.
My lord, I am
What the
unaware about the matter. My senior is not present. That's why 1 week time be given.
Let me see the impugned order at page 22 of the Honorable Single Judge.
All right. Defects have not been cured for over 8 years now. The court does not propose to give any further indulgence for this purpose.
My lord, 1 week may be given.
Yeah, the appeal is accordingly dismissed.
Lordship, in item number 11, Lordship, the writ appeal as the brief expert from the office of Mr. Prafulla Kumar Rath.
Which is the matter? The other man was arguing.
11 is called back.
We just now called 11. Somebody said
That
he
is
wanted
already
time.
disposed of.
Yes.
The power has been transferred, Lordship.
All right.
Mr. Prafulla Kumar Rath.
All right.
My lord, I am appearing. My lord, I am appearing. The power has been transferred to our chamber. My lord, I am.
All right. Fine. It's been dismissed. Right.
Supplementary list item 12.
Item 12, my lord, I pray for a pass over, my lord.
All right. Pass.
Item number 13.
None appeals dismissal, no prosecution.
Item number 14.
May I please, your lordship? The appellant has preferred an appeal against the order, against the single judge, honorable single judge bench order in WPC number 27,370 of 2013, my lord. Order dated 14/10/2014, my lord. See, the prayer of the appellant is that, my lord, he challenged the selection of Anganwadi worker, my lord. If your lordship will only on the ground that the clause number 10 of the advertisement has not been complied with and given appointment to the respondent number 5, my lord, illegally.
Which is the item number?
14.
So, my lord, can I have a glance to the writ petition number 272370/2013, my lord?
What? They scanned.
That has been disposed of.
Scanned 385/15.
May I place your lordship?
It's the hard copy.
Here in the writ petition before this honorable single judge, my lord, in WPC number 27370/2013, my lord, an advertisement floated by the respondent number 4 CDPO, my lord, in the year 2012, where it has been for the selection of Anganwadi worker in Badipatana 2 Anganwadi Center in ward number 5 and 6, my lord, where the selection was conducted as per the guidelines, and accordingly the opposite respondent number 5 has been selected as an Anganwadi center. This particular appellant has been selected as third because the respondent number 6 has been declared as the outsider. So this appellant stood second, my lord, in the selection list. Accordingly, she has given appointment engagement order as at Annexure 4, page 23, my lords. Have a glance to the page 23, where she's joined as 24/4/2013, she joined. But as per the stain, my lord, she has to produce a college living certificate on the day of joining, my lord. On the date of joining, she was studying in Rajsunakala College, +3 course, my lord. That has been reflected. I have annexed, my lord, at page 25, annexure 6, my lord.
No.
Kind of evidence.
Do the guidelines require that, or it was simply inserted in the advertisement?
Yes, my lord.
See, the ground on which the single judge has rejected your
Yes,
petition is that this requirement, which was clause 10 of the advertisement, did not form part of the guidelines.
Yes.
What is that?
Because
The guidelines did not require it, only the advertisement required it. So the single judge said this is not mandatory because the guidelines do not insist on production of the school leaving certificate.
That's right, Your Lordship. But so far my contention is concerned, my Lord, the selection process has been completed according to the guidelines, my Lord. But on the joining, my Lord, that has not covered under the guidelines, my Lord. That has to be taken care of at the advertisement. My Lord.
Why? On what basis are you saying that? Why will the guidelines not cover?
Because the appointing authority has issued floated the advertisement.
Advertisement can't override the guidelines. That way you can start including any new condition in the advertisement. The short ground on which the learned single judge has in the impugned order dated 14th October 2014 rejected the challenge raised by the present petitioner in Writ Petition Civil 27370 of 2013 to the selection of respondent number 5. Which one of them? There are 2 respondents here.
Yeah, respondent 5 has been selected and respondent 6 has been stood second, my Lord, in the selection.
Respondents 5 and 6 as the selection of respondent 5 as Anganwadi worker bracket AWW of the Anganwadi Center at Ranpur is that although the advertisement in clause 10 required production of the schooling certificate.
College leaving certificate, my Lord.
Sorry?
College leaving
certificate. All right. There was no such requirement in the guidelines. Paragraph. Learned counsel for the appellant does not dispute that the guidelines did not require fulfillment of such a condition, and it is only the advertisement which contains such a condition. Paragraph. Clearly, the advertisement cannot override the guidelines and insist on compliance of a requirement which did not form part of the guidelines. Consequently, the court is unable to find any error having been committed by the learned single judge in the impugned order. The writ appeal is dismissed.
Item number 15.
None appears dismissed, not possible.
Supplementary list item 16.
There is no instruction, my Lord.
No instructions dismissed.
Item number 17.
None appears dismissed, not possible.
Item number 18.
Memo is taken on record. Dismissed as no instructions.
Item number 19.
None appears dismissed, not possible.
Item number 20.
It has become infructuous, madam.
Infructuous dismissed.
Item 21.
No instructions dismissed.
22.
Same.
Item 23.
None appears dismissed and not possible.
Instruction, my Lord. 23 to 28, my Lord. No instruction, my Lord.
No instructions. 23 to 28. Correct.
Item number 29.
Delay. Let's see the delay.
My Lord, I am. Kindly pass over. Pass over.
See the delay. Oh, it's pass over, all right.
Yes.
Item number 30.
None appears.
No instruction.
No instructions, all right. Dismissed.
Item number 31.
None appears dismissed in opposition.
Item 32.
None appears dismissed in opposition.
Item 32, my Lord. I am appearing for CDA, my Lord.
All right.
Item number 33.
None appears dismissed in opposition. All connected matters.
Item number 34.
Item 34, my Lord, the file has been transferred.
Okay. So the appellant says the file has been transferred. None appears for the appellant. Dismissed in opposition.
Item number 35.
35 this matter I put take instruction. May I pay any other date or
No. Just tell us what the matter is about.
the matter is
Defects have not been removed, sir, for more than 7 years now. Defects have not been removed more than 7 years. The court does not propose to grant any further indulgence. The appeal is accordingly dismissed.
Item number 36.
None appears dismissed in opposition.
Present, ma'am. Here, my lord. Order dated 10/2/2015, my
You have
lord.
not filed a certified copy of the impugned order, sir.
Produce it within a week, my lord.
No. Tell us what the matter is about.
On 10/2/2015, my lord, the writ petition bearing case number 13718 of 2012, passed by the Honorable Single Judge, has been challenged in this case, my lord. The process of selection in this case, my lord, that was challenged. In that case, my lord, there is some provisions that was not given effect to, my lord, and some certificates, procured certificates have been used, and on that basis appointment was given, my. And this honorable court on the earlier occasion directed to conduct an inquiry, and inquiry they have not conducted in as per the rules, my lord. And the RI who conducted the inquiry on the spot, my lord, and they given the reply under annexure.
So please tell us, it's not clear at all what you are trying to argue. Please read the impugned order of the single judge.
My lord. Hard Lord in counsel for the petitioner and the Lawrence state. The petitioner has filed the writ petition challenging the order dated 21/3/2013 passed by the collector cum chief executive officer, Jila Parishad, Kendrapada, rejecting the claim of the engagement of Shiksha Sahayak, considering the submission.
So you applied for the post of Shiksha Sahayak.
Shiksha Sahayak.
That was rejected.
That was rejected.
By this order dated 21st March 2013. Where is that order, sir?
That rejection order.
Next file.
Annexure 5. Annexure 5 at page 56.
Come to page 57, sir.
My lord.
Penultimate paragraph. Read that.
The engagement of Shiksha Sahayak has been made on merit basis. The petitioner secured less percentage of marks than the others who were engaged from the merit list. The prayer of
what do you have to say to this?
My lord, if they were deleted, my lord, then I will be.
Naturally,
appointed.
if everybody else is deleted, only you will remain. Correct. That's a very good argument, sir.
4 to 6.
That's a very good argument. Best is to remove everybody from the list. Then only you will remain in the list.
Because by way of manipulation, they enter into the list.
What is that to show that, sir? What material have you placed for showing that?
Annexure 17.
Annexure?
Sorry, annexure. Annexure 7.
What is that?
My name reflects in serial number 93.
All right.
Sorry. In that case, my residential certificate, so far as the respondent number 4 is concerned, that is not there. That is manipulated, entirely
less
manipulated.
marks than the others. Why are you not focusing on that? You just now argued that they have all their marks. We asked you what is the material to show their marks were manipulated. What are you showing us?
My lord, so far as your lordship kindly turn to Annexure 1. In that event, my lord, so far as the criteria is concerned for appointment, in a particular block, appointment was made on the basis of that residential certificate.
Sir, the ground on which you have been
that is
not selected is because you scored less marks than the others.
Because of these persons, my lord, my selection was hampered, my lord, on the basis of these.
I think you're not able to explain the case properly, sir. Do you have the counter there?
No, my lords, there are two issues, my lords. One is that the persons have to be residents of that particular place. Like Anganwadi, this is also the same thing. So what he had said is that they had fake residential certificate. My lords may see page 57, the third paragraph, the second paragraph. The Tahsildar of Derabish, he had initiated miscellaneous cases to actually inquire into this fake residential certificate. And he said that they are all genuine.
Oh.
So, which is why all of them can be considered for this post. And clearly the other thing is that he has admittedly scored less marks than them. So, in any case, he's not going to get appointment. So, his argument is if the residential certificate are held to be fake, then they are out, then only he gets a chance.
Yes, sir. What do you have to say?
My lord, on the basis of that certificate, my lord, because of that fake certificate,
no, but they conducted an inquiry and found it's not fake.
That inquiry itself wrong, my lord.
There's no end to it. Everything is wrong, sir. No problem then. All right. The challenge in the present petition appeal is to 10th February 2015, passed by the learned single judge, dismissing the appellant's writ petition civil 13718 of 2012, in which the appellant had questioned her non-selection as Sikya Sahayak and had also questioned the engagement of respondents 4 to 8 as such. Paragraph. The case of the appellant was that respondents 4 to 8 had obtained fake residential certificates from the office of the Tahsildar Marshagai to the effect that they were residents of Garadpur block. And on that basis, their selection as Sikya Sahayak should be cancelled. Full stop. The counter affidavit filed in the said writ petition, in the counter affidavit filed in the said writ petition, it has been pointed out that earlier the appellant had filed writ petition civil 19434 of 2009 on the same ground, and the said writ petition had been disposed of by this court by an order dated 25th May 2000, electing the collector come chairman, CEO Zila Parishad Kendrapada to dispose of the representation of the appellant. Thereafter, the collector rejected the claim by an order dated 21st March 2012, finding that the appellant had scored less marks than the others who had been engaged out of the merit list. Paragraph. It appears that after the order was passed on 25th May 2010, the collector had issued notice to all concerned and also directed to be present for a hearing, and also directed the Tahsildar or Marsagai and Derabish to conduct an inquiry and report about the genuineness of the residential certificate issued by the respective Tahsildars in favor of opposite parties, respondents 4 to 8. Full stop. These inquiries revealed that the residential certificates were not fake. As claimed by the appellant. Full stop. In any event, on merits also, the appellant having scored less marks than the response 4 to 8 could not have been selected. Full stop. Paragraph. The learned single judge has declined to interfere after noting that the appellant had scored less marks than respondents 4 to 8. Paragraph. Consequently, the appellant contends that the inquiry itself was not properly conducted, and therefore all the others selected should have been eliminated from the merit list. To stop, the court is unable to agree with the above submission. To stop, there is no material whatsoever placed on record to show the inquiry itself was not conducted properly. Full stop. With the appellant having scored less marks than respondents 4 to 8 on merit, there is no error committed by the learned single judge in rejecting the claim of the appellant. There are no grounds made out for interference. The writ appeal is dismissed.
Item 37.
None appears dismissal or prosecution.
Item number 38.
None appears dismissal or prosecution.
Item 39.
No instruction. No instructions.
Item number 40.
40, my lords, as an instant, I do admit and apologize as regards the removal of defect. If your lordships allows me, I'll remove the defect and thereafter your lordship may hear.
Not necessary, sir. Just tell us what the matter is about.
So the appeal is against the order of the single judge as regards cancellation of result of the petitioner. The respondent hearing, and wherein wrongly he had been awarded 35 marks and that was detected thereafter, actually, whereas he has acquired 15 marks. Thus, he was declared fail. But the Honorable Single Judge, on the ground that there is a violation of natural justice and promissory estoppel, as follows. Your Lordship may come to page 14 of my appeal grounds. I have stated therein at ground number 2 that having taken account, your Lordship may kindly allow me to place the ground there. But the judgment order direction is otherwise bad in law and arbitrary for the reason that the Honorable Single Judge has not properly taken into account and has not properly appreciated the factual aspects leading to the final action of the university in regard to the case of the petitioner, though raised by University Council and hence liable to be dismissed. Thereafter, that the Honorable Single Judge has, next page, my lords, 15, has erroneously held that the action of the university in cancelling the result of the petitioner at the later stage without prior intimation to him is hit by the violation of principles of natural justice and the principle estoppel, particularly when it was urged by the University Council that the result of the petition having been declared by the university was purely provisional, and it was well within the legal domain of the to revise the same, and the error having been committed would never be allowed to be perpetuated in the hands of the authorities at the helm of affairs, and hence is liable to be set aside. Thereafter, the next ground, single judge has not...
This is a very strange way of arguing a case, sir. Simply reading grounds.
No.
You have to first show what is wrong with the impugned order of the single judge.
No, I first laid the grounds before you place the grounds before your lordship for the reason that thereafter I would explain that...
Sir, the time is all past now. You start explaining now.
Sir.
Tell us what is wrong with the impugned order of the learned
The only the thing that I have to place before your lordship is as regards the principles of promissory estoppel, that doesn't apply to the statutes. And that apart, a wrong having been done cannot be perpetuated when it was detected at the level of the authorities. And
what is the answer to saying there's a violation of principles of natural justice? What is your answer?
A principle of natural justice, where the learned honorable single judge has held, is of the what I oppose. It's opposed to my stand in the appeal is that principle of natural justice is not bound to be followed in a case where such wrong has been detected.
What does that mean? When you detect a wrong, it's your version of what is wrong or what is right. The person going affected by it has to be given an opportunity of explaining or not.
In the counter, I have explained that it was published in the...
Publishing is not the answer, sir. You're publishing the cancellation. You're not giving them a chance to explain before taking a decision to cancel. That is what the single judge has pointed out.
Malons.
You say the challenge in the present appeal is to an order dated 23rd December 2014 passed by the single judge, allowing writ petition civil 22918 of 2013 filed by the respondent, seeking the quashing of a notification dated 24th November 2010 and a subsequent notification dated 20th December 2010 issued by the appellant university, cancelling his result in the +3 final degree bracket examination 2010, declaring him as single quotes fail. Full stop. One of the grounds on which the learned single judge has quashed the above notifications is that much after the appellant had, the respondent had been declared pass, it had also been granted by the university. He noticed that the mark sheets and certificates of the +3 examination did not carry any registration number. Full stop. The respondent therefore approached the appellant university to get his mark sheets and certificates corrected in order to submit them for the purposes of his employment. Full stop. It was at that time, it was at that stage that the university informed him that there were no such mark sheets or provisional certificates. He had already been declared single quotes failed in the exam since December 2010, that is 6 months after the publication of the result. Full stop. The respondent had to then apply under the RTA Act and only thereafter obtain the impugned notifications on 30th August 2013. Full stop. It was rightly contended that by the respondent that he was not put on advance notice by the university before the cancellation of his earlier result and declaring him as failed. And in the meanwhile, he had already pursued higher studies, obtained a degree of MA in Public Administration from IGNOU, and therefore, at a late age, his BA result could not have been changed by the university behind his back. Paragraph. Counsel for the appellant sought to contend that the mere publication of the failed result was itself sufficient compliance with the requirement of national justice. Full stop. This court is unable to agree with this submission. Full stop. The cancellation, the publication of a failed result was made by the university admittedly 6 months after declaring the student as pass, and any material had come to the notice of the university compelling it to change its decision, then clearly the respondent should have been put on notice and given a chance to explain before declaring him as single courts fail. Full stop. This is a classic case of violation of the principles of natural justice and has therefore rightly invited interference by the learned single judge. The court finds no error having been committed by the learned single judge in passing the impugned order. There is no merit in this appeal. It is dismissed as such.
Item 41.
None appears dismissed and non-prosecution.
Item number 42.
Is infructuous, my lord.
Infructuous dismissed.
Supplementary list item 43.
None appears dismissed and non-prosecution.
Item number 44.
Delete.
May I please, your lords? My lord, there are also other
Yes,
two petitions, miscases I have filed for substitution.
It's all right.
Yes.
Tell us what the matter is about.
My lord, the matter is like this. The case land has been purchased by the father of the owner, my lord, from OP5, my lord. My lord, the consolidation appeal, my lord, that was allowed in our favor, and the revision it is set aside the appellate court's order, my lord. Against that, my lord, the writ petition is filed, my lord. In the writ petition, my lord, the petitioner lawyer died, my lord. In the meantime, my lord, my lord, in the writ petition, my lord, that was issued, notice was issued on 23/5/96, my lord. In 27/10/98, my lord, order passed.
Recall order. You filed an application in 2006 for recalling an order.
My lord.
My goodness. All right.
My lord, thereafter, my lord, this honorable court, my lord, in this honorable court, I have filed the petition to set aside the order of writ petition, which was dismissed.
Yes.
My lord, that was dismissed for default on account of lawyers'
All right.
presence, my lord.
All right.
At that time, the lawyer who was engaged.
You have to follow up on these matters.
My lord, the
You
lawyer,
can't just go off to sleep. If you entrust papers to a lawyer, you have to follow up on the matter.
my lord, but the concerned lawyer was died, my lord.
So what? If you had found out, you would have known. If you had been visiting your lawyer, you can find out.
My lord, and also the petitioner number 1 died, my lord.
All right.
My lord, thereafter the
See, ultimately, it is about what diligence. With what diligence do you pursue your matters?
And single judge said that there is the right occurred in favor of the opposite parties. My lord, the Lawrence single judge judgment, my lord. Page 8, my lord. My lord, page line 9, my lord. The delay being for quite considerable period, and when for the said reason, a right has occurred in favor of the opposite parties, which is not is a valid reason to dismiss, or a valid point to dismiss the petition, my lord.
All right. The challenge in the present appeal is date 13th April 2015, passed by the learned single judge in CM APL 194 of 2010, declining to recall an order dated 3rd November 2006, passed by the learned single judge, dismissing OGC number 4293 of 1996 for default. Paragraph. The ground urged before the learned single judge to explain the delay in filing the application for recall was that not only the counsel who conducted the case on behalf of the appellant had died in sometime in November 2003 without the appellants being aware of it, but even one of the appellants had died. And therefore, it was only in 2010, when the son of appellant number 1 had come to Cuttack and wanted to meet his lawyer, that he could know that the writ petition had been dismissed for default on 3rd November 2006. Full stop. As rightly pointed out by the learned single judge, there is absolutely no explanation from the side of the appellants as to what prevented them from even collecting information with regard to the status of the writ petition for such a long period. Full stop. Even before this court, learned counsel for the appellant is unable to give any convincing explanation for the inordinate delay in approaching the learned single judge for recall of the order of dismissal in default. In the circumstances, the court is unable to find any error having been committed by the learned single judge in rejecting that said application. The writ appeal is accordingly dismissed.
May I permit to say, my lord? Only 1 minute. The petitioner may approach the civil court, my lord, because this order has come from the consultation court, my lord. The petitioner, if any right, they may appear before the civil court.
No. Sorry.
Item 45.
There is a delay of 667 days in filing the present appeal, which is not properly explained. Consequently, 526 of 2015 is dismissed and the writ appeal is accordingly dismissed. Yes.
Item 46.
Counsel for the appellant seeks leave to withdraw the present appeal. Dismisses withdrawn.
Item number 47. 47. Item 47.
None appears. Dismissed for non-prosecution.
Item number 48.
48, no instruction.
No instructions dismissed.
Item number 49.
Item number 49 to 57, my lord, no instruction.
No instructions. All right.
Okay.
57. Okay.
Item number 58.
58, no instruction.
No instructions dismissed.
Item number 59.
None appears. Dismissed in no prosecution.
Item number 60.
None appears. Dismissed in no prosecution.
61.
61, may I please, my lord. My lord. My lord, I am challenging the order of the learned single judge. That is, lordship, kindly see page 53, the operating part, lordship, kindly see. My lord, the short question involved in this case is that the petitioner belongs to scheduled tribe. The caste is Sahara caste. It's undisputed fact. And also the husband of that lady also scheduled tribe. The short question is, they both of them divorced. As per the customary right, my lord, and that society, they gave the certificate that yes, divorce is there. Learned single judge, and also this is the order of the learned single judge. His earlier, my lord, what happened? He got appointment in the Anganwadi worker. As per the guideline, 2 guidelines are there. Statutory rule is not there. In absence of the rule, my lord, the executive instruction will cover the rules. So as per the executive instruction, as per the advertisement, the petitioner is to submit the written statement and also the affidavit. That is the requirement. And also, if the lady is divorced and destitute and deserted, then 5% bonus mark will be given. Accordingly, entire document you filed and he got the appointment. Then what happened? Subsequently, another lady he made some allegation before the learned SDG, learned ADM. ADM without any material facts, and he disbelieved one document and said that no, your appointment is terminated because I wrote this. Then subsequently against that order, what happened, my lord? I filed a case before the learned single judge. Let's see, we can see case 53. The operative person, let's see 53. May be permitted to read, my lord.
Sir, all permissions granted, sir.
Sir.
All permissions granted.
Sir, I'm obliged, my lord. 53, let's kindly see.
Yes.
The second paragraph I'm reading. After having heard counsel for both the sides and on perusal of the documents on record, the fact which is not in this is that the petitioner has made an application for consideration for her candidature being scheduled tribe and divorced deserted. Full stop. In the guideline 25/2007. And even in the earlier guideline, which is not applicable. The provision has been made to give some preferential mark on account of being scheduled caste, scheduled tribe candidate, and some preferential marks on account of being divorced deserted candidates. The purpose of giving the preferential marks in the guideline is to give some benefit to such category of candidate who have no means of livelihood or facing the financial hardship for sustaining their document for consideration to be given 5% of preferential mark or any weightage in the matter of consideration of engagement. The additional district magistrate, after verifying the document and after going through the letter dated 10/4/2013, have been issued by the President Vishwavasu Sabara Association, has not accepted the said letter as a valid document for the purpose of treating the petition as divorce. The court sitting, my lord, the court sitting under 226 of the Constitution of India in the matter of Anganwadi worker is supposed to look into the legality and illegality of the order passed by the additional district magistrate, my lord. Learned counsel appearing such and such not relevant. So my humble submission before this unroot, my lord, let's kindly turn to page 23, the advertisement. As per the advertisement and as per the notification dated 2/5/2007, both the documents are essential for appointment of the Anganwadi worker, my lord. Both the documents is satisfied also. So
what is the what both documents?
I'm bringing. Let's kindly see page 23. Let's kindly see page 23. There is no rule. So 23 is governing the field. This is ODI document. Subsequently translated in the English, my lord. So in the English translation, I'm reading. Page 23, advertisement 6/4/2013. In 6/4/2013, that is in paragraph 5, it is said that destitute, deserted women, 5% mark will be given the bonus. So, the next page, in paragraph 11, it is very categorically said, widow, unmarried woman above 35 years, destitute, deserted women can furnish the written statement. I also produced the written statement.
No,
also,
what did you produce, sir?
Sir, I produced the written statement.
No. You did not produce any. What you produced is there in page 54. Come to page 55, sir.
Yes, 53, 55.
Second paragraph.
54, 55. I'm reading. 55. Yes, the second. Yes, 10/4/2013.
Kindly read that second paragraph, sir.
Yes, the additional district 55, the additional district magistrate, after verifying the document and after going through the letter dated 10/4/2013, have been issued by the President Vishwavasu Sabara Association, has not accepted by the
You simply produced a letter by the President Association that the petitioner and her husband had appeared before that association, and has, on that basis, they just arrived at a settlement in that association.
That's correct.
And that basis you wanted to contend that they were divorced.
No, what? Yes, yes, my lord. Yes.
So this is the only point in the whole case. Except this, you're arguing everything else.
No, that is true, my lord.
So anyway, that's different. We have to figure out what the point in the case is. So you have now figured out what the point is.
What happened in this case?
How do you, on the basis simply of a statement made before an association, claim that you're divorced?
My lord, on both.
And on that basis, you want 5 essential marks?
My lord, what happened, my lord?
There is no declaration by any court, nothing of divorce.
Court's declaration not.
You want the ADM to simply accept that I have produced this association's letter and therefore I am divorced.
That's what kindly appreciate. My humble suggestion is, if you will say, if you will appreciate that yes, the declaration from any competent court is required for divorce matter, my lord, I have no case at all. But
that's why you have no case. Exactly. You have now come to the correct point, sir.
Yes.
After going all around the place, you have now come to the correct point.
Because
how do you claim you're divorced in a marriage declaration by a court? And you want a statutory authority to accept simply because you make a statement.
That is true, my lord. Lordship can appreciate both husband and wife both are settled tribe. As per the Hindu marriage,
whatever, sir, there has to be a proper declaration by a competent court.
That is true, because there is a custom.
You're claiming appointment in a civil post.
That's correct.
On the basis of a certain status, and you want that to be accepted merely on some letter of some association.
Because association, because both of them.
Anyway, there's no interference, sir. No, there's no ground for interference.
Let's have kindly 1 minute. Let's have kindly appreciate. Only 1 minute. Let's have see one judgment of Odisha High Court. Of course, you also may not appreciate. Both the parties belong to scheduled tribe. Hindu Marriage Act doesn't apply. Wife is entitled.
They need not, sir. Who said the Hindu Marriage Act has to apply?
That
declaration, sir, the declaration that a marriage has come to an end, that there has been a divorce, that has to be by a competent court, sir.
Competent court,
whichever, whether it's customary law, traditional law, whatever.
No,
you can't simply go before an association and get a letter from an association for that.
80 association.
Don't expect some association letter to be taken so seriously.
But apart from association, nowhere in the competent court means.
Then you have a problem, sir. Then you have a problem. Yes.
That is your lordship. That is my only point. I mean, because this honorable court. Because
I know that point has come now after us asking you.
That is correct, my lord. Association, because the divorce in the tribal society, the association is the competent association to say
that may be your understanding, sir. That may be your understanding. Yes.
But the tribal people, lordship, can see where they will go and how they.
We don't know, sir. If all problems under the sun, don't expect only the courts to find answers.
That is why Hindu Marriage Act is not applicable. That is
all right. Nobody said Hindu Marriage Act is applicable. Yes. The challenge in the present writ appeal is to an order dated 13th October 2015, passed by the learned single judge, rejecting the appellant's writ petition civil 18337 of 2015, thereby negating the appellant's challenge to an order dated 9th September 2015, passed by the Additional District Magistrate in Anganwadi Worker (appeal) number 5 of 2013, whereby the selection made of the appellant as Anganwadi Worker (AWW) was struck down. Paragraph. Admittedly, the appellant belonged to a scheduled tribe and applied for the post of AWW for the Kalangapadi 2 Anganwadi Center. She claimed preferential marks on the basis that she was a divorced scheduled tribe woman. Full stop. In proof of having been divorced, what the appellant produced was a letter issued by the president of the Bishwa Basu Sabar Association, dated 10th April 2013, to the effect that the appellant and her husband had arrived at a single court's settlement, unquote, before the association. Stop. It is on the basis of the above document that the appellant was claiming 5% preferential marks for her selection as AWW. Paragraph, the learned ADM has, on examining the said document, come to the conclusion that it cannot be the valid basis for treating the appellant as a divorced scheduled tribe woman, and therefore cancelled her selection as she had wrongly been given 5% preferential marks. The learned single judge was not satisfied that any ground had been made out to interfere with the order of the learned ADM. Having heard Mr. Das, learned senior counsel appearing for the appellant, the court was not convinced that the above letter issued by the association could have formed the basis for the appellant to claim 5% preferential marks to establish that she was a divorced scheduled tribe woman. Stop. There had to be, as pointed out by the learned single judge, there had to be a declaration issued by a competent court in that regard, without which the appellant could not have laid a claim to those preferential marks. There is no error committed by the learned single judge in passing the impugned order. There is no merit in this appeal. It's dismissed as such.
Item number 62.
My lord, 62 on behalf of RK Raut, my lord. My lord, kindly next week, my lord.
No, just tell us what the matter is. Just tell us what the matter is.
It's a PL matter.
Yeah, let's see what it is.
Notification of 67 is challenged that they claim that it should be denotified with regard to Wildlife Sanctuary Division in Puri. This notification at Annexure 3 of 1984 and Annexure 4 is of
1987.
1987. This law is prevailing for last more than 40 years.
The challenge in this writ petition is to notifications issued way back on 23rd April 1984 by the Forest and Fisheries Department and 1st September 1987, demarcate under the Wildlife Protection Act, demarcating boundaries of
Wildlife Sanctuary.
The Batu, what is that? What's the name of it? Please. Balukhand.
Balukhanda.
Konarak Wildlife Sanctuary.
Balukhanda Wildlife.
So these notifications have held the field for well over 35 years now. And it is too late in the day for the appellant to have woken up in 2016 to challenge them. Full stop. There's no valid explanation given for the obvious delay and latches in seeking such a relief before the court. Consequently, the court finds merit in either writ petition.
There is a connected matter, same.
No merit in the writ petition, and it's dismissed as such. The connected matter, you say, in view of the dismissal today by this Court of Writ Petition Civil 14941 of 2016, the present petition is also dismissed.
Item 63.
I am appearing for opposite part number 6, my lords.
May I please, your lordship? Lord. May I please, your lordship? Lord, I prepared a death chart. If kindly. Lord, may I please, your lordship? Lord, here the petitioner prays the honorable court to issue a writ in the nature of writ of quo warranto, directing the opposite parties, more particularly 2 and 3, under which authority OP number 5 is holding the post of director. No rules provide, and if they fail to so cause, the honorable court is pleased to declare OP number 5 as a usurper.
Before you start, sir,
yes, Lord.
Just come to the cause title.
Yes, Lord.
Just come to OP, OP number 5, your description.
Yes, Lord. Dr. Bardakant Mishra.
What is his age, sir?
57.
Which year? Which year did you file this?
I filed in 2016.
So what is his age now, sir?
Oh, my lord, might be taking that he might be superannuated now.
He will be.
It will. No, but still, if the cause of action arises, my lord.
How will it arise, sir?
Because the my lord, he was appointed on, he was serving while.
Once he is superannuated, how is any cause of action surviving?
No, because for that period, he was
period, that all period is over.
No, my lord. What I am saying, my lord, just 1 second. 2011, he was his period for director has been completed. So he was utilizing the post of director till he left this place, my lord. Your lordship may see for after 2011 till he left this place. He cannot utilize that post as a director. My respectful submission is this, my lord. Your lordship may see.
So we are not prepared to entertain it, sir. It's a waste of time. We're not going to waste our court's time examining such issues.
No, he is no more here also. When there was a lot of hue and cry here, he was left from here. Well, just 1 second. He left from here to and appointed somewhere as Goa. And the authority, what they say, and authority said, yes, that he has been on Leon, he had been gone to in the post of scientist H. So he was utilizing the post of director here. Even in 2016 also, 15 and 16, your lordship may see the souvenir purpose, he was posing himself as a director. So the period.
As on date, he is no more in this office.
That is admitted, my lord. That is admitted.
Very kind of you, sir. Very kind of you.
But no, not kind of me.
Yeah, right.
Because 2011, till his retirement, while he was here, he was utilizing the post of director.
All right. The challenge in the present petition is the prayer in the writ petition is for quashing the appointment of opposite party number 5 as a scientist in the Institute of Minerals and Materials Technology, Bhubaneswar.
And even the apex court hold one thing.
Party number 5, even as per the description in the cost title, was 57 years at the time of filing of the present petition in 2016. Counsel for the petitioner does not dispute that by now opposite party number 5 has superannuated. In fact, apparently, he even ceased to be a director during the pendency of the petition itself. With the issue having become purely academic, the court is not inclined to entertain the present petition any longer, and it is dismissed as such.
Union of India appearance in Union of India, this judge.
No, the apex court has also said that nothing can be done except glaring him as a usurper. So my respect is only limited to that only. That from 2011 till he was there, he was opposing himself as a director and utilizing his post as a director. That is the only my case.
Item number 64.
Item number 64, no instruction. No instructions dismissed.
Item number 65.
None appeals dismissed.
Item number 66.
Delay is
delay is 77 days, my lord.
All right. Delay is condoned. The trial court record the requisition. The paper books be prepared within 8 weeks thereafter and supplied to counsel of the parties. This 1514 is allowed. 1515 stay realization of the amount of fine that's disposed of. 1516 of 2022, you say not pressed at this stage.
Item 67.
May I please your lordship? Appearance have been convicted under section 301 on 49 IPC.
Yes, admit. All right, sir. Admit the court record by requisition. The paper books be prepared within 8 weeks and supplied to counsel to the parties. Thereafter, the appeal be included in the list of final hearing matters. There shall be a stay of the collection of fine. That is 1517. 1518, you say not pressed at this stage. Right.
Supplementary list item number 68. 68.
None appears dismissed, not possible.
Item number 69.
Item 16, may I please your lordship? We filed this application challenging the illegal construction of a Kalyan Mandap community hall at in the district of Mayurbhanj.
There's no stay order here, sir.
No, madam.
So that my Kalyan Mandap is there for more than 5 years now.
Yes, madam.
Why should we interfere at this stage?
My lord, you should take instruction.
No. You say the challenge in the present petition is to construction of a Kalyana Mandap in the Kapti Pada block in district Mayurvanch. Stop during the pendency of the present petition. There has been no interim order passed with the court. The Kalyana Mandap in question has continued for well over 5 years. The court in the circumstance not inclined to interfere at this stage. The petition is dismissed.
Supplementary item 70.
May I please? My lord, this is PIL file against the corruption of Mahatma Gandhi National Rural Employment.
So you can go to the Lokayukt, sir.
My
The
lord,
subject matter of the present petition, it will be open to the petitioners to approach the Lokayukt in accordance with law. The petition is disposed of. Right.
Now, we are applying for opinion number 7.
Yes.
Item number 71.
May I please, Your Lordship? Within the limits.
Delay is condoned. All right. Dispensing with is also allowed. What is the matter about, sir?
Implemented is at page 59. The option he has exercised his option to come to the revised scale of pay in the year 1985, 89, and 96 in the year 2012. So we have rejected it. The Honorable Single Judge has directed to allow his option and also input a cost of rupees 5,000 with 7% interest. Page 67 is the input.
So what is your ground?
The ground, my lord, he has exercised his option in late that there is a time fixation for change of option. That we have rejected it. Your Lordship, I can find it from page 54. That was the order of rejection. His pay was fixed in 1985 and 89 in the year 2002 and 2004. As per that scheme, as per the ORSP rules, he had to exercise his option within 3 months. He did not exercise his option in time. So we have framed a resolution under 2012. It does not fall within that resolution of 2012. So accordingly, we have rejected it.
All right. It's a notice. Notice be served additionally through counsel appeared for the respondent before the learned single judge. Till the next date of hearing, there shall be 25th January.
Item 72.
May please, Your Lordship. And this matter is covered by my Lord's judgment under Annex 8. And Your Lordship may.
This is not a PIL.
May direct
No, it's not a PIL. It's a place before the roster bench.
Lordship may direct the opposite party number to take a decision in the light of Annex 9, page 38.
Place before the roster bench on 28th September.
Supplementary list item number 73.
Your Lordship, I seek for a passover.
Let's first see what the matter is about. What's the delay? Delay.
Delay is there 4 months. I have filed a chronology of events.
No. What's the delay, sir? How many
4
days?
months. 4 months.
4 months. So you'll have to explain, sir. What's the give us what does the application say?
Kindly complication. Page 2 of the application, in case 6/30 of 2016.
Nothing at all, sir. There's no explanation.
No, Your Lordship, may kindly appreciate one thing. I'll just let you to the merits. Why? Because here is a question of waiver which was not considered by the learned single judge. Now the facts are like this. An advertisement was made for the post of my lord training associate in 1995. My lord, the number 1 applied. He was not a regular employee. Then my lord, in 90, when he was not selected because he was under the unreserved category, and he stood second. My lords, thereafter he filed this OJC number 9754 of 98, claiming for regularization to be appointed the training associate. My lord, thereafter, my lords, in 2005, he again filed another WPC 2483 of 2005 direction regularization. In this matter, in 2005, in 2015, an order was passed by this honorable court regularized. He was regularized in a junior scientist in 2015. Thereafter, after this aspect, the learned single judge goes into and says, no, that matter is maintainable, still maintainable. Well, my submission is that once he filed the 2005 writ petition, he gave up his right so far as 98 writ is concerned. In 2015, an order was passed that was prior to this judgment. And thereafter, my lords, this is brought to the knowledge of the.
I think, sir, these are not big, great matters for.
No, your lordship will kindly appreciate. Difficulty is this. It's already been regularized in 2015.
It's all right. You see, there's a delay of 120 days. 115. Okay, 115 days in filing the present appeal. The explanation offered in the application for continuation of delay is not satisfactory at all. Stop. These are routine administrative delays, and as explained by the Supreme Court of India in Postmaster General versus Living Media, and the subsequent judgment in Berulal versus State of Madhya Pradesh, or State of Madhya Pradesh versus Berulal. This sort of an explanation is not acceptable for condoning delay. Consequently, the court is not inclined to condone the delay in filing the appeal. The application is dismissed. Consequently, the appeal is dismissed.
Item 74.
Milord, this certified copy of the impugned order, Milord, I am filing today, Milord. Matter may be called next week, Monday, Milord.
No. Tell us what it is about.
Milord, the order of the MSME, Milord, MSMEC, Telangana has been challenged on the ground of a jurisdiction, Milord.
Yes.
And Milord, this copy was not filed, but office note was not made, Milord. And I am in accommodation till tomorrow, Milord, because of the illness of my wife due to cardiac arrest, Milord. Milord, Lordship may call it next week any day, Milord. The defect may be removed and matter may be SRP made, Milord. And I have also filed my appearance, Milord. Since 14/3/2022, my name is not sorry, I discovered this, Milord. And Milord, it is a transport brief. The earlier counsel is dead, Milord. So Lordship may call it Monday, Milord. Monday, Milord.
No, the single judge has simply said you have a remedy by way of an appeal, sir.
Milord, only ground of a jurisdiction, Milord, it was challenged, Milord. Milord, how the case will be filed when the agreement was signed in Odisha, Milord? The case was filed in Telangana, Milord.
File an appeal against that order, sir. That award you can challenge an appeal. Same grounds which you've raised in the writ petition, you can challenge in the writ appeal.
Lordship may dispose it on Monday, Milord. So
no.
Milord, I am in difficulty. My name is not there first, Milord.
No difficulty, sir.
Milord, I am.
There is nothing. It's a 1.5 page order. You know what the order is. You're just now arguing also. It's on the ground of jurisdiction.
No, I have not prepared.
Nothing.
Milord. I am
Please.
Mind, Milord.
Please.
Milord, I am in accommodation till tomorrow.
All right, sir. We've heard you. You can challenge the
accommodation, Milord. Milord, only I pray for Monday, Milord.
All right.
I will not be misunderstood, Milord.
All right. The challenge in the present writ appeal is to an order dated 17 September 2019, passed by the learned single judge, rejecting
Milord, can it not be passed on Monday, Milord?
14937 of 2019 on the ground that the appellant has an efficacious statutory remedy by way of an appeal under Section 19 of the Micro, Small and Medium Enterprises Development Act 2006 against the award passed in the matter by the Telangana Micro and Small Enterprises Facilitation Council in terms of the MSME Act. In the terms of the MSME Act paragraph. The learned single judge has in fact referred to the decision of the Supreme Court of India in Goodyear India Limited versus Norton Intech Rubbers Private Limited, 2012 2 CTC 829. Having heard learned counsel for the appellant, the court is unable to find any ground to interfere with the impugned order of the learned single judge. Indeed, all the points urged by the appellant in the writ petition can well be urged in the appeal under Section 19 of the MSME Act. before the appellate forum, leaving it open to the appellant to urge all such points in accordance with law. The court declines to interfere with the impugned order by a single judge. The appeal is accordingly dismissed.
There are also other grounds, my lord.
And all other
on this
grounds.
jurisdictional ground, my lord.
And all other grounds. So you can raise all those grounds in the appeal. Yes.
Item 75.
Yes.
May I please, Your Lordship?
Yes.
So, Lord, we are ready to deposit the amount, statutory amount here, my lord. Your Lordship, may I hear this, my lord?
All right. Yes.
Your Lordship, this appeal arises of the order under Annexure 1, Your Lordship. Your Lordship, may kindly peruse page 36 of the appeal memo, Your Lordship.
Yes.
Your Lordship, this matter is taken up by video conferencing. Heard Sri S.K. Mishra, learned counsel for the petitioner. Sri S.P. Panda, learned additional comment advocate. Sri learned, Your Lordship, the relevant paragraph is that Sri Mishra, learned counsel for petitioners, fairly submit that there is no such obstruction and the petitioners have no such intention. For recording of the submission of Sri Mishra, learned counsel for the petitioner, court finds there is no need of any clarification. The interim order of this court will, however, be subject without creating any obstruction to other users utilizing the common area of the for the required purpose, Your Lordship. This was a
Sir, all this can go under the RERA Act. Why have you gone to the writ petition?
Your Lordship, I have not gone to the writ petition, Your Lordship. I'm the opposite party in the writ petition, Your Lordship. I have come against the interim order, Your Lordship. There was
point out, sir. You point out that the writ petition is still pending.
Yes, Your Lordship.
These are only interim orders. We'll expedite the writ petition if you want.
No, Your Lordship. In this writ petition, Your Lordship, in IF clarification was even filed. IA for vacation of the stay order was filed. IA for clarification was filed, and the Honorable Judge has clarified that no clarification is required. In spite of that, the respondents are creating hindrances, Your Lordship. I have filed an additional affidavit. Your Lordship may kindly peruse the additional affidavit. Annexure 12, Your Lordship.
Yes.
This is a letter written by the Additional Commissioner BMC to the DCP, Your Lordship, with reference to the subject cited above and WPC number this and this and the IA this date order dated this under reference. I am to show that the BMC Construction and Demolition Squad has made an action plan for cleaning of debris and seed materials at Jaidev Tower, Bihar on dated 31/5/2022 at 11 a.m. Therefore, it is requested to deploy police force at Jaidev Tower, Jaidev Bihar, Bhubaneswar to maintain law and order situation, Your Lordship. Even though the court has clarified that the respondents will not obstruct, but they are obstructing and the BMC is unable to clean the debris, Your Lordship.
No. Who is the respondent who's creating obstruction?
Private respondents, Your Lordship.
No. This letter, the BMC simply says they're going to clear the debris.
That is my contention, Lordship. If Your Lordship may direct that the debris may be cleaned, then
we don't have to clear. Already the BMC is written for police protection.
But Your Lordship, the debris is unable. Your Lordship may kindly peruse Annexure 5, Your Lordship. Even after these directions, what is the status, Your Lordship? I have annexed the photos. Demolition order has already been passed, Your Lordship. This debris is lying, and I am just approached this court for cleaning of the debris. I am nowhere standing in the writ petition, Your Lordship. My only humble prayer is that this debris may be allowed to clean, Your Lordship.
Yes, Mr. Mishra, whom are you appearing for?
I am questioning the very maintainability of the writ appeal itself. This is against orders. Not only that, Your Lordship will see 2019 order has been challenged, no limitation petition, and 4-5 orders has been challenged in one writ appeal.
And
so therefore, the writ appeal itself is not maintainable. It is just like, my lord, that.
Why have you filed an appeal?
I have filed a writ petition against the order of the BDA authority, Your Lordship, challenging their action, and that is pending. They want the entire thing should be demolished. My lord, they have got flat there, they are staying there, and it's just like mythological, my lord, person Bhasmasur. They want that.
No. This writ petition is just tagged along with the appeal, is it?
Yes, that's all. So that's a honorable single judge matter. That may be hard, but this writ appeal is not maintainable, being against interim orders, which are not in the nature of final orders. This is just in furtherance of the case. And
no, but he says the debris should be cleared. That's all.
That Your Lordship has been pleased to clarify. That today morning I took instruction after the matter came up. But it is clear. And that is what the honorable judge has been pleased to observe. And here, my lord, he challenges only in the guise of, Your Lordship will see a writ appeal which is not maintainable.
No, the debris has already been cleared.
Yes, my lord.
Oh, I see.
Your Last time also that submission was made and the photos are annexed thereafter, Your Lordship. Last time this submission was made, the interim order was passed, and thereafter I have clicked these photos and annexed these photos, Your Lordship. If they are saying that it has been cleared, Your Lordship may only direct that the debris may cleaned and they will not stand in the way. If that this prayer is allowed, I have no objection, Your Lordship.
If there is any violation, they can go in contempt, my lord. If there is any violation.
All right.
There
You
is no
see,
violation, Your Lordship.
the challenge in the present appeal are to certain interim orders passed by the learned single judge in writ petition civil 20212 of 2019. We'll stop without going into the merits of the contentions. The court would only like to observe that one of the grievances of the writ appellate is that the debris lying in the premises has still not been cleared. We'll stop Mr. Samir Mishra, learned counsel appearing for the respondents in the appeal, maintains that the debris has been cleared and further states that in the event there's any violation of the orders passed by the learned single judge, appropriate proceedings can be instituted by the appellant for that purpose. Paragraph. The court is not inclined to interfere with the interim orders of the learned single judge at this stage, and therefore it is disposed of. However, it is requested that the writ petition be heard expeditiously and disposed of as early as possible. We'll stop for this purpose. The writ petition will now be listed before the roster bench of the learned single judge on 12th October 2022. Right?
Your Lordship,
Your Lordship,
fixing it,
13th October. 13th because 12th, Your Lordship has been.
All right, 13th. 13th of October, my lords. Yes.
Your Lordship, if the debris has not been cleaned, only one line in the order that the debris may kindly be cleaned, Your Lordship. Only one line in the order.
That's all right, sir. They have said that it's already cleaned.
Sir, Your Lordship, they have also said it the last time, and thereafter I have clicked the photos and those photos have been annexed, Your Lordship. On the last occasion, the writ also they have said this, Your Lordship.
May I pray? I am appearing for the Bhubaneswar.
Nothing has been provided to me, my lord.
Mr. Please wait. I am appearing for Bhubaneswar Municipal Corporation. For the writ appeal, I am not there. My name was not there, but the connected matter in this next matter, my lord, I am appearing for BMC. So, with regard to the cleaning of the debris, my lord, I will take care. I will see that it will be cleared.
Counsel for the BMC assures the court that the debris will be cleaned. Right. If not already done. Right.
I am appealing for Bhubaneswar Development Authority. My demolition order is being carried out. Municipality is carrying it out.
Right. Right. All right.
Item 76.
Well, so far as that writ petition is concerned,
that will be listed on.
That will be listed before the roster bench.
On 13th.
Single judge matter.
On 13th. Right.
Well, it's item
76.
The appeal preferred by the state.
What the delay?
Whereas the delay is 44 days.
All right. Delay is condoned. Is there some defects?
The impugned order is at page 18. The petitioner wanted regularization. He had been appointed as a cook on daily wage basis, but the writ petition, my lords may see the impugned order, the writ petition on which reliance has been placed, that pertains to my lords regularization of contractual workers. However, my lords, this particular issue is also before my lords in a batch of writ petitions. That is, my lords, coming up on 10th of October. The lead writ appeal 137 of 2022.
All right. Notice returnable 10th October. Till the next date, the impugned order shall remain state.
Grateful.
Delay is continued.
Item 77. Supplementary 77.
None appears dismissed. Oh.
Lord, it's a fresh matter. Let it be passed over.
Pass over, correct.
Item 78.
As item 78, my lords, this is a case where the
in this
petition
case,
was disposed
I have
of.
been instructed to appear on behalf of opposite party.
What's the delay?
This was filed during
581 days. So it's all beyond even the COVID period. There's an ordinary delay of 581 days in preferring the
As the order is 24/12/2020. So that's a COVID. period.
What's the explanation? COVID.
Yes. Yes, this is a matter where the petition was disposed of on the first day, my lords. My lords have passed.
If you're agreeable, then it can go back to the single judge.
There are so many days of limitation, my lord.
The entire thing is during COVID period, sir.
500 more than 500.
That's right. The entire thing is COVID because it's December 2020 and then COVID started in March 21. I mean, even that was COVID period only in December 2020.
Yes, these are, my lords, similar matters where my lords have
Yes.
first day disposal. My
Correct.
lords have remanded the matters.
Correct. You see, if the reason stated therein, the delay is condoned. Notice, he accepts notice. It is seen that the impugn order was passed on the very first day without any opportunity to the appellant to file any reply to the writ petition, which involved questions of fact which required reply in a counterfeit. On that short ground, the impugn order of the learned single judge is set aside and writ petition civil. Where's the impugned order?
It's page 46. my lords.
Page 50?
It's page 46. my lords.
Petition 37278 of 2020 is restored to the file of the where will be listed hearing on November 2022. The appellant will file its reply to the petition on or before 26th October 2022 and rejoinder will be filed before the above-mentioned date. Also, no further time would be granted for this purpose. The learned single judge is requested to proceed in accordance with law and endeavor to dispose of the writ petition and merits as expeditiously as possible.
May I submit one line? Of the writ petition before honorable single judge, my status quo may be maintained.
All right, the status quo be
Of the
maintained till
respondent.
then. All right.
Obliged.
Supplemental list for orders item 79.
My lord, the appellant filed a prayer for bail, my lord, in last occasion.
Yes, may I please, your lordships. Your lordships are directed us to find the mental condition of the patient, my lord. He is in custody since 11 years. On this 18th October, he'll be completing 11 years. But he is found to be schizophrenic. He's under treatment and medication he is stable.
Still 11 years is a long time.
Yes, that your lordship can understand. And moreover, I think in merit also, there are no eyewitnesses that if your lordship.
All right. IA number 48 of 2022 on instructions. The additional government advocate states that the appellant has already completed over 11 years and 6 months in custody and is undergoing treatment for schizophrenia. Full stop. Considering the number of years already spent by the appellant in jail and with the present appeal not free to be taken up for hearing in its turn, the court directs that the appellant be enlarged on bail during the pendency of the present appeal, subject to the satisfaction of the trial court. The IA is disposed of.
Item number 80.
80, my lord, this is on behalf of Mr. Mishra, defect remove maybe within 5 days. This is fresh item.
Yeah, you say admit the defects be removed within a week. You see, trial court record by requisition. Paper books be prepared thereafter within 8 weeks and supplied to counsel the parties. Thereafter, the appeal be included in the list of final hearing matters. There is no IA, nothing.
No, my lord.
All right.
Item number 81.
81.
Made please to the Lordship. Lordship, in this petition, the petitioner is challenging the gradation list of assistant law officer. The pendency of this case, more than 9 years has already been passed, and the petitioner is, in the meantime, petitioner is retired from his service. My lord. So I believe no cause of action
events, the
Lordship,
petition has been rendered
order of
infractuous.
superannuation of filing affidavit. I'm appearing on behalf of opposite party number 2.
Anyway, he himself saying it's infractuous. All right. Has been rendered infractuous. It is disposed of as such. All right.
Item number 82.
82, my lord, great appeal is not maintainable. The same may be withdrawn with liberty, my lord.
Counsel, the appellant seeks leave to withdraw the writ appeal.
82.
Writ appeal seeks liberty to seek other appropriate remedies as may be available to the appellants in accordance with law. Disposed of is withdrawn with liberty as prayed for. In view of the order passed today in writ appeal 445/2014 and writ appeal 2 of 2015, the present contempt petition is disposed of. Achha, the contempt petition you just say is directed to be listed before the roster bench of the learned single judge.
So far as contempt?
Yes, on 21st November.
Your lordship is fixing the contempt to 21st. That is already disposed of because their order has already been complied.
It's been complied with?
Yes. That is, we have filed the affidavit. Any grievance so far as the contempt is concerned.
Copy finding. No copy items are none.
Lord, it's a old matter. Since 2015, we have filed the compliance affidavit and everything is there.
All right. And so you say contempt case 74 of 2015, compliance affidavit filed. The petition is disposed of. All right.
Item number 83.
83, my lord, I'm the petitioner. This is a PIL filed by the villagers complaining about illegal operation of a railway siding. Now, the railway siding has modernized in the year 2010 without having the appropriate EIA sanction or the environmental clearances. And there is no also state pollution clearances, nothing there on.
It's never came up also for hearing, sir.
Madam. And the railway has not even filed their counter.
The last 7 years. Who's appearing with the railways? No, there's some railway pollution control board.
Pollution control board has filed a counter saying.
No, Southeastern Railway has also filed.
No copy has been served.
Your lordship, we have already filed the counter. We'll serve a copy on the counsel for the petition, your lordship, and counsel for the
Still
petition.
they are continuing with their illegal things and without having the requisite environmental clearances. Madam. That's not good.
No, it says the good shade is not coming within the purview of the state pollution control board.
Good shade, we are not. We are on the railway siding. Siding is a red zone. Siding, as per the notification, is coming under the high pollutant potential. They admits to operate this railway.
But they say the Kalinga railway siding is not coming under the consent administration of the pollution
Consent that may not be of the OSBC, some other authority. That the consent application they have filed under for a wrong authority. That is what they say. It has to be under the district environmental impact assessment authority. It has to be filed there and otherwise as a state environmental impact assessment authority. Without filing there, they have filed it before the OSBC and they say this is not coming under a consent administration. Impact assessment has not done, though it is a modernized in the year 2010. So that 2006 notifications.
Who's for the state?
number 83.
But we have not made that. Some principal secretary, Home Department, you've made. Government of Orissa.
Yes, madam.
How are they concerned with all this? You yourself made the State Pollution Control Board a party.
Yes, madam.
Yes.
Yeah, I've made for them party. Principal Secretary to Home, Principal Secretary to Government of Odisha, Chief Secretary, I've made this state government as party.
No, who's the relevant party, sir? You're
Relevant
you're
is
not,
actually a collector to, because they
you're not made the,
yes, madam. It is also.
Achha. The collector Sundargarh has to file a reply
Yes,
then.
we'll file.
The collector Sundargarh will file a reply within 4 weeks. List on 1st February.
Supplementary list item 84.
84, my lord, because of some personal difficulty, I could not be able to coordinate with the, my lord, this is, so this side, this is
Food security.
I could not be able to coordinate with the officials, my lord, to file an affidavit as per your lordship's earlier order. Lordship, grant me 10 days time, I'll file an affidavit.
Last order, my lord had said that they are not.
Yes, my lord, that he has given me a copy of that amicus curiae report. I had sought for time, my lord, and I could not be able to coordinate with different officials because WC department is involved, this food processing supplies department is involved. So therefore, Lordship, grant me 10 days time, I'll file an affidavit.
Mr. Tripathi, learned additional government advocate, 10 days time to file an affidavit in terms of the order dated 24th August 2022. The affidavit will be filed positively on or before 1st November 2022. List on 20th December. All right.
Supplementary list item 85.
May I please your lordship? This is regarding the construction of the road, and only for one village they have deviated, made a revised plan, and your lordship kindly have a glance to the affidavit of the opposite party number 6 dated 26/4/2022. 26/4/2022 in para 3, they have categorically stated that the work Balot to Dhipmala via Gudpangi in PMGSY road under package number so and so since January 2021, as about 17 number of villagers are not allowing the agency for construction of the work, and only to give the weight for one village who has having alternative road, and to deprive of the 17 villagers and more than 17 villagers, they have deviated the construction work, and the other that village on which they want to take the road, they have approached one of the applicant approached the Green Tribunal. That there the stand of the government is that, and flag B, the Green Tribunal judgment is there. Lordship, kindly have a glance to that judgment, para 13. The state respondents are categorically in their averments in counter affidavits that mere administrative sanction for the proposed works does not result in finalization of the proposal for construction of the road inside the village forest of Gudupangi, that one village, as there are several other procedures to be followed before work can actually be undertaken under PMGNREG scheme, and only approval of the collector DPC is not sufficient for execution of the MGNREGS work. The procedure has been outlined in their counter affidavits, and it is stated that after a project work under the PMGSY scheme is approved, it is assigned to the user agency, which in this case is the BDO Nuagan. The user agency, after assigning, calls for a Grama Sabha meeting, village meeting, and for execution of the process of work, a resolution to that effect is required to be passed by the Grama Sabha. The user agency then, along with the Grama Sabha resolution Form A of the Forest Rights Act 2006, applies to the range officer of the concerned area to furnish his report and submit clearance for execution of the project along with the topographical and geo-reference map of the areas to be included for execution of the work project. The range officer, after conducting a detailed field inquiry, then submits his survey report in flag B of the Forest Rights Act 2006. Form B. regarding acceptability of the project with respect to its impact on environment, wildlife, site-specific recommendation, if any. The Form B is then sent to the divisional forest officer, who finally disallows the project. And in the next paragraph, from the facts emerging in the affidavit of the state respondent, we find that as of now, only administrative sanction has been accorded for the proposed PMGSY road. The remaining essential formalities entailed in Form A and Form B under the Forest Right Act 2006 are yet to be processed. No survey report has been placed. Let them place that Form A, Form B, all sanction has been granted by the appropriate authority. Nothing has, no Police Sabha has done, and they have deviated scheme. Earlier annexer to the first scheme and the estimate they have made, that has concluded all these formalities. But in annexer 9, they have the revised estimate they have made without all these things, formalities they have not completed as on date. Let them produce that Form A, Form B, the Gram Sabha conducted, everything has been followed in accordance with law.
Yes.
They have not followed it. And more than 17 villagers is going to be affected for only this one village. And it is this Gudupangi villagers also allege that the connected writ application also allege that because the road is passing through the jungle and no forest clearance has been granted, though that said road cannot be, proposed road cannot be going that way. So all these formalities, without complying these formalities, they cannot deviate the estimate and pass the road in other way, only to accommodate one village. And it is also in their affidavit, they have said the construction work could not proceed because since January 2021, and because of these several villagers' objection. And why for so many villagers going to be affected for only one village? And another thing, because there is very much political rivalry between this one village and so many, more than 17 villagers. If that road will pass through that way also, there will be always the law and order situation. And this is not in the interest of the larger public. The annexure to the initial plan estimate made is in accordance, but this revised estimate they have made with an political motive and only to accommodate one village, which is also not in accordance with law as per their own counter affidavit filed before the Green Tribunal.
Your Lordship may kindly remember this case. Two group of villagers, they are quarreling with each other that this should be the road, that should be the road.
Who's appearing in the companion writ petition?
Only thing is that...
No, 1 minute. 21456 of 2017, nobody's appearing.
And he's on the line, my lord. That is in virtual mode.
Mr. Dalla, Sankar Pani.
Is he on the line?
In this 21456.
The connected writ petition.
No, 21456 of 2017.
And they are the OP number 12 to 14 in the present, the first writ petition, my lord.
No, but where are they?
And one litigation is going on before the NGT. I have been
That is what I am saying. Not only
So,
one disposed of, another.
why the
Several cases are pending, multiple cases. So let them go to NGT and get a final solution to this.
No.
Because all these matters relate to the environmental law.
No.
Parallel proceeding is also not allowing because the date is fixed to 13th October.
NGT already granted, no formality has been completed. It is premature. Yes, NGT in their judgment clearly says that it is a premature because no formality government, because of the counter of the government.
He doesn't know there is another case. That is original application 106 of 2022, Dasarathi Swami versus State of Orissa.
Stand of the government.
And the list of hearing, the date of hearing is 13th October.
That is in context of another villagers. We are not fighting.
But the dispute is the same.
No.
You
cannot say, let me go.
May Lordship, in this matter, I have filed in Wakalatnama for respondent number 121340.
Gudupangi village.
Yes, Lordship. Lordship, this matter, in fact, the PIL filed before your Lordship and the original application 106 of 2020 relating to the plot, same everything. In fact, the prayer before your the prayer in the PIL, they have been seeking
Let
that.
them supply a copy and let them file counter. Without supplying
No, no,
copy, without
even-
counter,
even
they
what-
are saying from their mouth.
Even what?
Because I have given a order of the NGT, and if they have filed any case, let them file counter and supply the copy. Let me go through it without going through it, and they will go on saying.
Lordship, this matter
have to give
itself
counter.
is not maintainable.
I-
This matter itself is
no,
not
no.
maintainable.
You file counter first,
this
then you
is
submit
relating-
whatever you like.
This is relating to application of forest conservation. They want a land
That
to
is
be
not
taken
ours.
without.
That is not our stand in our case. You file counter to our read.
Mr. Bali,
Then,
Mr. Bali,
You have.
if this is how you proceedings are going to be conducted, we'll simply mute all of you. Yes.
Lordship, may I be
Yes.
permitted, Lordship?
Yes.
Lordship, in this case, because the realignment, the very
I have to give a reply to it.
Mr.
also.
Bali, please do not interrupt. When you were arguing, nobody interrupted. Yes.
Lordship, the impugned document, the annexure 8 itself is self-explanatory.
But how can you go on submitting?
Kindly, I have already
Just
filed
mute
my
Mr. Bali.
wakalatnama.
Just mute Mr. Bali, please.
Lordship, kindly come to page 78. Page
Yes.
78. In fact, the realignment is made only on the ground. There is involvement of forest land to the extent of 600 meter. One. Secondly, the even by realigning this the road project, the connectivity between two places doesn't get any kind of interruption. Rather, it reduces the distance, reduces the budget, and also it also avoid the forest land, because in any case,
do you want to file a reply or not?
Lordship, today only I have filed my wakalatnama. In fact, if your Lordship permit me, then we'll file my.
You don't have to. Yeah, if you want to file a reply, you file. No question of permitting, not permitting.
Lordship, we'll do that.
Is a counsel appearing for opposite parties?
Twelve to 14, Your Lordship.
12 to 14 who are residents
12
of
to 14. Bar here, so
35174.
First one, first matter.
Pudupangi, village Pudupangi, states that he'll file a reply within 4 weeks. Rejoinder that too, if any be filed before the next date. While the state will file a reply clarifying the stand purportedly taken by it before the National Green Tribunal, Kolkata, in original application 12/2021/EZ, which is reflected in the order dated 29 September 2021 of the NGT, a copy of which has been made available to the state council. List on 31st January.
The wakalatnama may be taken on record and our name is kindly reflected in the
All
contract.
right. All
My
right.
lord, the other matter is connected matter is
Yeah, the
there.
connected list along with, yeah, on the same date.
Deeply grateful, Your Lordship.
Correct.
Item number 86.
It is
We have not sought a copy of the amendment in this case. Last now he has given the copy. I may be allowed.
My lord, the amendment is formal. My lord, on the last occasion, your lordship has directed to bring into the records the
No, I have
office.
objected.
Kindly please, you're with me for 1 minute. Let me. My lord, on the last occasion, your lordship has directed to make all the office who are in a writ application to record, my lord. That's why I have, by way of amending the court title, my lord, in IN number 709 of 2022, my lord, I have brought them into record, my lord, by filing this amendment. As per the direction of this lordship, my lord, your lordship. The amendment is formal, my lord.
They
were the person to whom I have.
During pendency of this case, now the appellant have sold their property to the disputed property. Therefore, they have no right. During pendency of the appeal, they have sold the property.
No, my lord, not to that effect. I have no instruction, my lord.
You better find out. Counsel for appearing for opposite parties.
4, 5, 6.
Respondents 4, 5, and 6 states that during the pendency of the present appeal, the appellants have already sold away their property to
outsiders and third party.
To certain outsiders. Counsel for the appellant states that he needs to take instructions. This application for amendment is allowed for the reasons stated therein. The consolidated petition we filed is already filed or not?
No, I have not filed.
We filed before the next date. Within a week, you say, within a week. It's on 1st February, interim order to continue.
Item number 87.
May I please, my lord? My lord, I pray this matter may be taken up last week of October, my lord. Because this migratory bird are going to fly after October 15. Migratory, it's related to the Mangala Judi case, my lord.
Right.
And so the migratory bird, they generally used to come after October 15th, my lord. So I pray, my lord, as the counter, they have filed, my lord, the directive fishery. So everything will be clear, my lord.
What will be clear? You have to file a response. If you want to file a response, you have to file a response.
October last week, my lord, or November first week, my lord.
Why should it be? Who's appearing for the other side?
My lord, I am for the other side.
Mr. Mishra
We have filed the affidavit. That he has to respond, that our affidavit.
Correct. Mr. Mishra seeks some more time to respond to the affidavit of the state. The affidavit in response be filed before the next date. List on 3rd November.
Item 88.
This one is item 88. This, my lords, pertains to my lords opening of a PHC, that Achyutpur village. As I filed a compliance affidavit.
You've opened it or not?
No, I'll explain, my lords. As per the IPHS guidelines, which the state has to follow, and it's a uniform guideline followed across the country. The opening of a PHC requires certain parameters to be seen. One of them is, my lords, population. My lords may see the letter which I have annexed on page 6, my lords, of my of the affidavit.
30,000 and 20,000 area. What is the population of this village? 19,409.
It's 19,419. So that does not come, and since it's a uniform, any deviation from it.
Who's going to pull you up? If it's a court order, why should you be bothered? When there's a demand, why don't you open a PHC?
As the subcommittee considered this, that, my lords, will find at page 5. And
you keep taking time for opening the new PHC. You filed an IA and now you've completely changed track.
No, my lords, in our previous affidavit also, we had mentioned that this population...
No, you filed an IA,
yes,
8788. You said, give me more time to open a PHC.
Because the proposal was still pending with the subcommittee. Now, my lords, page 5, the subcommittee has finally taken a decision. So,
it seems to be overreaching the court.
My lords, may direct. Because once, my lords, we open a PHC, and
it's all for good only. It's not like some largest giving or something. It's after for health.
Yes, my lords. But there are, my lords.
So wherever there's a demand, you should have a PHC.
Yes, my lords.
Maybe you should revise these norms.
These are Government of India norms. So
nothing. Nobody said Government of India will not pull you up if you open more PHCs. This is the minimum norm for opening a PHC.
My lords, may call it post vacation. My lords, give put it on
In
affidavit.
fact, you can combine a few more villages. If the population is to come to 30,000, you combine a few more villages.
Please, ma'am.
Ah.
Please, ma'am. I'll come back with the
Find out ways to open rather than not opening it. An affidavit has been filed on 21st September 2022, stating that the subcommittee which met to consider the matter decided that no hope for establishing an additional PHC in the Tangi block, since the population of all the 22 villages comes to 19,419, which is less than the population parameter of 30,000 for a plain area as determined by the, what is IPHS?
As it is Indian Public Health Standards.
As per the Indian Public Health
Standards 2022.
Indian Public Health Standards bracket 2022. 2022 bracket IPHS paragraph. It must be noted here that earlier an application had been filed seeking extension of time to open the PHC at Achutpur. Full stop. If there is a demand for opening an PHC, clearly there is a need felt by the villagers. Full stop. If the issue is about population, then the respondent should think of adding a few more villages, which can be served by the PHC to be opened at Achutpur. Full stop. Counsel for the state states that he will again seek instructions in light of the above observations and place and record the further decision of the state. This is on 6th January. Sorry, 5th January.
5th January. Password matters. Passover
matter. Right. Supplemental list pastor matter item number 12.
It please your lordship.
Yes.
The 12, there are some subsequent developments. So those things have to be brought on record, and so fresh petition will be filed, liberty may be granted to that effect.
All right. Counsel for the appellant seeks leave to withdraw the present appeal with liberty to file institute fresh proceedings in light of subsequent developments. This post office withdrawn with liberty is paid for.
Obliged.
Item number 29.
29, yes. My lord, similar type of case, day before yesterday, your lordship has issued notice that sell deed is will not pay the deficit court stamp duty. Same, this is Bobita Padhi and this today's case is Ashok Padhi. State versus Ashok. Same 157, your lordship has issued notice, today is 158.
Notice returnable, same order.
The date is there.
Same order. All right. List along with 157. Right.
Item number 77.
Yes, 77.
Supplementary
arising out of
77.
a civil suit. Civil suit. Certiorari power has been exercised purportedly. Yes, that is against the order of the Honorable Single Judge. Civil matter. The injunction was.
If none appears despite a passer, we'll just give you one more chance. In the interest of justice, list on 9th November.
Hearing one. Supplemental list for hearing, item number 89.
May it please your lordship. Your Lordship, this criminal appeal arises out of a conviction that had been passed by. Your Lordship, this criminal appeal arises out of a order of conviction passed by the learned court of Special Judge Mayurbhanj Paripada, Your Lordship. Initially, FIR was registered against 5 persons. That is Karanjia PS case number 48 of 2000 for the commission, which was registered for the commission of offences punishable under section 147, 148, 302, 329, 149 of IPC, Your Lordship. The FIR was registered against 5 persons. The gist of the FIR allegation is that on dated 24/4 in the year 2000 at about 12 noon, the informant along with a group of villagers, the informant and these villagers belong to one village called Nodagaudia. They went to another cashew field, government cashew field, that is located in another village at some distance from their village. They made an assembly and they decided to pluck cashews from that government field, Your Lordship. When the present informant, along with others, reached the spot of alleged spot of occurrence, there were already some villagers from the other village, that is Malharpada, were present over there, who were also apparently guarding the cashew nuts. There was a war of words between the faction of 2 villages, and subsequently there was a tussle between the members of both the villages, Your Lordship, out of which 2 persons got injured and 1 person lost his life. In the FIR allegation, it has been stated that the present appellant is the person who has given a stab injury to one deceased, whose name is Nandru Ho, Your Lordship. And thereafter, the trial had commenced. 10 persons of the village Malharpada faced trial before the learned court. Out of the learned trial court was pleased to acquit all other persons of the offences alleged. Your Lordship, in the meantime, the offence of section 35A of SCST Act was also added, and all other persons were acquitted. All the 9 other persons were acquitted of all the charges, and the present appellant was convicted of section 302 IPC, read with section 325 of SCST POA Act, and was sentenced to life imprisonment, Your Lordship. The present appellant was inside custody from dated 27/4/2020, and subsequently, after serving a term of, as far as we have instructions, it is 6 to 7 years. He was released from bail by this honorable court, Your Lordship, on appeal bail, Your Lordship. A brief background about the appellant, Your Lordship. As the present circumstance stand and as the report has also come by, the present appellant is a person who is a semi-paralytic person who is living alone at his house, Your Lordship. There is nobody to look after him.
How many injuries on the?
Your Lordship, the deceased only has 1 injury, Your Lordship.
I see.
The deceased has 1 injury, Your Lordship.
Can we see the medical evidence?
Yes, Your Lordship. The medical evidence of the doctor is PW4, Your Lordship. PW4, Your Lordship.
Page 109, my lords.
Para 2, Your Lordship.
109
Yes, Your Lordship. There is only 1 stab wound, Your Lordship.
on the abdomen.
Yes, Your Lordship.
We'll confirm.
The entire intestine has come out.
No,
it's very ghastly. Liver has been cut.
No,
But
Your Lordship.
nevertheless, it's 1 injury
on face of record. It
All
may
right.
seem as
And it seemed to be a clash.
Yeah,
Yes,
it seemed to be a class. No previous enmity was there. If I
Correct.
can
No,
honestly
Your Lordship.
confide.
Previous enmity is there. The statement
No,
of
I'm
prosecution witnesses is there.
All right. All right. Okay.
I'm trying to help you that way.
Yes, Your Lordship.
All right. We'll convert
happened
it
at the
to
spur of the
304 part 2 and we confine it to period already under court.
Your Lordship, I'm not sure about the period that has already been undergone, but I have to put, I would firstly argue before your lordship that even the statements of the
No,
eyewitnesses.
no, but what's the period undergone?
Your lordship, as far as we have instructions, it's
No, 1 minute.
5
Let's
to
just
6
see
years. We don't know that. We have no definite instructions.
1
as to
minute.
8 years.
You have the date of his arrest? The IO's evidence will tell us that.
27/4/2000.
The arrest?
Yes, your lordship.
Because he was released on May 2005.
Yeah, that is 5.
Approximately 5 years. All right. We'll confine it to the period undergone.
Your lordship, but can I also submit before your lordship that 304 part 2 will also not be made out against the accused? Your
No,
lordship?
no, no.
There are eyewitnesses.
No, your
It's
lordship.
all right. It's all
Your
right.
lordship, if I may be permitted to submit, even this eyewitnesses version, these are first time before the court.
All right. It's all right. It's all right. Okay.
Even those are first time before court, and all the witnesses are interested witnesses, not because they belong to villagers of any other the other village, because a counter case is also pending in which these persons only are the accused,
All right.
and the weapon of offense has not been seized, your lordship.
The counter case is still going on.
Counter case, as far as I have, we have no instructions, but we have the number of the counter case.
We
Your
don't
lordship.
even know that. We'll go by the evidence here. That's enough.
They're injured eyewitnesses, ma'am.
Your lordship may be injured,
they have
not by the present appellant, but not by the present appellant.
No, that may be, but they were present there and they've got injured.
Your lordship, their presence is doubtful because of their evidence. That is what I'm contending. Because of the first time before court,
All right.
they have not disclosed the same before the investigating officer.
All right. We'll discuss that. All right. We'll reserve orders. But
Your lordship, may I be permitted to submit before your lordship, because I need to show your lordships where are the discrepancies, because
all
on
right.
the face
Continue after lunch. Then. We'll continue after lunch.
obliged, your lordship,
All right.
because on the face of it, it seems an open and shut case.
All right. All right. Okay. After lunch.
Obliged, your lordship.
My lord, I may pardon, my lord. My lord, that 74, my lord, your lordship direct me to paper appeal. I will, so for limitation, my lord, we will file appeal not later than a month, my lord. Lordship may say.
All right. All right.
Oblige.
Namaskar. Sir. Good afternoon, Justice Patnaik. He's not able to hear us, I think.
Namaste, my lord.
Namaste, namaste.
Supplementary list for orders, item number 1.
My lord, in this item, may I please, my lord?
Yes.
My here, the first item will be dependent upon the second item, which is a fresh one. And on the last occasion, your lordship was pleased to issue notice to the other side. But
Yes.
my grievance was as against at best 2 crore 20 lakhs, a valuation of 4 lakhs, 4 crore has been made without any basis. Your lordship, considering that, was pleased to issue notice. As it appears from the list, my lord, your lordship will see in the second item, no reply has been received, nor anything has been solved to me also. But I have annexed document recent to show that in fact the sale value can at best be 2.2 crores per acre, nothing beyond that. And there is no other documentary evidence or material to show contrary. And your lordship was pleased to issue notice to the other side. I have given copies, my lord, as per your lordship's direction.
This is about the current market value.
Exactly, Your Lordship. Now it is at best 2.2 crores. That is nothing, and their authority suggested 2.2 crores. They have made it 4 crores without any material, Your Lordship will see.
My lord. You have filed a reply or what? Have you filed a reply?
My lord, in the one case, my lord, 6488394 of 2020, I have replied this case, I have filed a counter, my lord.
No. In the IA.
No, my lord, they have to file in the main substantive case, Your Lordship, the second case. The IA will be only extension depending on what Your Lordship will decide in the main case, where Your Lordship has been pleased to issue notice. And my friend Mr. Nath, appearing for the endowment authority, has to file in this fresh case. That is the second item in the list.
Right. All right.
Yeah.
When are you filing your reply?
Yes, my lord.
You say in IA, you say, sorry, in petition civil 11201 of 2022, Mr. Nath appearing for opposite party number 2.
I am for opener 2, my lord.
States that he'll file his reply within 4 weeks. Rejoinder if any for the next date. We'll have to have is there some status quo order or something? No. All right. List on.
I think they will not interfere till Your Lordship adjudicates, ma'am.
Right. List on 2nd December. All right.
Will Your Lordship say something little earlier? No, madam. It's not. As Your Lordship, yes, because I'll not disturb Your Lordship.
All right. 18 November. Sorry. 18 November.
Deeply obliged, ma'am.
All right. All right. Namaste.
CMC, they are ready in the field to show your ships.
Lordship, item number 92.
92 item. Yes, they are ready in the field.
Yeah.
Yes. Item number 92.
Right.
All developmental work on progress going on. Thank you.
Water supply connections. पानी खोल के दिखा. The Lordship may ask them, the manholes are opened. Manholes are kept open.
That's okay. Hmm. I think they're still constructing these manholes.
Yes.
Tiling is still going on, I think. What about the sanitation? I mean, toilets and other things?
Sir, city health officer is
Sir, namaskar, sir.
Yes.
Sir. Sir, one SSG has been appointed for the sanitation, sir.
Okay.
And one door-to-door collection separate vehicle is also allotted, sir,
Okay.
for this slum, sir.
All right.
And two time sweeping and lifting is going on, sir.
All right. All right.
Sir. This is the road, sir, main road, sir, inside the basti, sir.
All right. All right.
this is community hall, sir.
Mission Shakti
Community
hall, sir.
I see. All right.
Sir, work is going on in every lane, sir. 53 lane.
All right. All right. All right, sir. All right. All right. Fine.
Thank you, sir.
You have anything else to say?
Your Lordship, I do accept that after the intervention of this honorable court, they have done lots of work. And
Right.
after intervention of learned senior also,
Good.
He has personally taken care of that.
All right. All right. All right. You say the court has viewed the situation in the
Jagatpur, Neempur.
in the Neempur resettlement and rehabilitation colony in real time. to stop the officials of the Cuttack Municipal Corporation present at the site explained that regular collection of garbage and sanitation facilities is being undertaken, and sanitation facilities are also available. The other aspects have been dealt with. No, you say as regards the availability of a public health center, it is stated that the Jagatpur Urban Public Health Center, located at a distance of 500 meters from the colony, would cater to the needs of the colony people. Stop. There are stated to be primary schools and a high school located within a distance of 1 kilometer from the colony. Full stop. It is acknowledged that on account of the intervention of the court, the situation in the colony has improved, and that the senior counsel for the PMC has also ensured that the directions of this court are complied with in letter and spirit. You need to have this matter on them.
One more time, Your Lordship, I need that. Because just for final hearing, Your Lordship.
What is there for final hearing?
Because on the aspect of
there for final hearing.
Because the order dated 27/6, Your Lordship has asked for schools, condition of the school. That school is overcrowded. I do agree some students have shifted from old schools, but it is overcrowded. Only on that part I want to press me on the next date. That will be the last date. I have no issue, Your Lordship.
But they've mentioned the schools in the
Yeah, Lordship, they have, but it is more than capacity. The students have.
It is.
There is no other schools.
Don't expect anything immediately.
No, I do agree, Your Lordship. I do agree. It is not possible.
You make a representation, you can take it up separately then. You make a representation. If, according to counsel for the petitioner, there is still a need for an additional school in the area, then it will be open residents to first petition the CMC in that regard, and after following up on such representation, to seek appropriate remedies.
But one thing is, so far the school is concerned, it is concerning to state government. School management is never
to the CMC, okay, to the state government, you say.
Yes.
To the state government. All right.
Accordingly, petition is dropped.
Not, we'll close it.
Yes.
No further directions are therefore called for at this stage anymore. In the petition, it is accordingly disposed of.
Deeply obliged.
All right.
That item 89.
Your Lordship, I only wanted to bring to this Honorable's court notice about 3 points, Your Lordship. That first of all, these eyewitnesses have stated all this for the first time before court, Your Lordship. That was PW1, who is an injured eyewitness. At page 91, he clearly says that I was never examined judging the FIR, Your Lordship.
Mm-hmm.
And PW2 also, again at page 99, he says, I have not been examined by the police in this case, Your Lordship. And this is also subsequently corroborated by PW10, Your Lordship, who is the person who has allegedly transferred these persons to the police station, brought these persons to the police station to lodge the FIR, that the police has never examined him. That is in page number 133, Your Lordship. So my only contention is, Your Lordship, and this has been also confirmed by the IO, that they have not stated all this about the assault part before him, Your Lordship. So my only contention before Your Lordship is, although these eyewitnesses may have given statements, elucidate statements before the Honorable Court, but it cannot be forgotten that they are stating this for the first time, Your Lordship. Also, one more aspect is the Learned Trial Court goes on to say that these witnesses cannot be called as interested witnesses, maybe because of the fact that they belong to another faction of village. But our contention is, we are not terming them as interested witnesses because they belong to other faction, but because of the fact that there is a case pending against them which has been lost by a person from our village only, and all these witnesses are accused persons in that case, Your Lordship. And also, third point, Your Lordship, if Your Lordship would appreciate that, in this case, during the trial, the defense never got the due opportunity to avail to represent any witnesses under Section 243 CRPC. So what had happened? That contention has also been taken in the appeal, Your Lordship. That is there in the paperwork. So what had happened is, that is also there in the lower court record, Your Lordship. So also what had happened is, we were supposed to, the defense had given an application to adduce the sarpanch of the village in which the cafe was located, and another independent witnesses. So one day, as the defense counsel informed the court that they were not able to, that the proposed defense witnesses were not able to be present in the court. So the court may issue summons from, so summons may be served on those witnesses from the court, Your Lordship. But the Learned Trial Court termed this as to be a mere act to delay the process, Your Lordship, and hence rejected the same, Your Lordship. For the same, we had also filed CRLMC 3406 of 2002 before this Honorable Court, and this Honorable Court was pleased to direct us to adduce the defense witnesses if the judgment had not been delivered, Your Lordship.
Right.
That had not been discussed, Your Lordship. And I'm obliged that Your Lordships have taken the views to convert this, to do the period undergone, Your Lordship. But it's just that I wanted to bring all these points before the court's notice, Your Lordship.
Well, what my sister is saying, actually, I don't have any idea regarding I was also wondering why they have not taken this in the defense degree of alibi, or that they were not present in the spot. That is a false implication, all those things that were not there in the defense. So now that she's saying that, my lord, I need to examine that if Your Lordship will have it. But I was just suggesting, if there's a clear-cut eyewitnesses and they have seen, and the corroborating medical evidence of stab injury on the abdomen, yes, honestly, my lord, no weapon has been recovered. That is one lacuna with the prosecution. But nevertheless, all these are occurrences witnesses and 2 injured eyewitnesses. So the Learned Court below, in its own wisdom, has relied on them. But and I was suggesting that whatever Your Lordship is saying is 304 Part 2 appeal to undergone is definitely a very welcoming.
Yes, yeah, I do welcome that.
All right.
Would like
We pass the detailed judgment.
Yeah.
All right. What is reserved?
Your Lordship, if I may put one more request concerning other matter in the weekly list, Your Lordship. Actually, item 8 was supposed to be argued by Mr. D. Naik, Your Lordship, but he's on an accommodation in the second half, Your Lordship. He had to go out of state for some personal emergency that has arisen.
All right.
Obliged, Your Lordship.
All right.
Supplementary list item number 90.
Well, sir, I'm appearing for the appellants, Balku Oram. The appellants challenge the order of conviction for life imprisonment for offense of murder. That is under 302 IPC passed by the trial court. The fact is case that mentioned the judgment that on 17/2/1998 at about 5 p.m. the youngest daughter of Manav Bodha Naik of village Gundawali Lukura died. At this, the family members of Manavadha Naik challenged the Puni Naik by saying to be a witch. They alleged to Ama Jioku Kaichu, you have eaten our daughter. Thereafter, it is alleged that
Both the accused person came and dragged Puni Naik from her house and took her near the house of Manavada Naik. There, they assaulted Puni Naik by means of a lathi severely. At this, the informant, the PW3, the carrot and challenged the matter. The accused person also tried to assault PW3, but she managed to escape from the spot. Thereafter, at about 12 p.m. or 1 a.m. in that night, this is Puni Naik died. On the next day, that is 11 a.m., the informant PW3 Sukra Naik, a girl of 16 years of age, at the time, went to the police station along with her maternal uncle and recorded the matter at the police station. My humble submission that to substantiate the charge, prosecution has examined 9 PWs. And while the accused person have examined none of them, except the informant who was lodged orally reported before the police, no other witnesses have supported the prosecution. So my kind asks the deposition of PW3, the informant, that is page
38.
38. I know the accused person. At the time of the deposition, he was 18 years. I know the accused person about 2 to 3 years back at night. Both the accused person took my mother, Kuni Naik. That in fact, that is Puni Naik. It is Kuni Naik. That is only discussed that Kuni Naik and Puni Naik same are one person. From our house and beat her by body. In the house of both the accused person are brothers and live in one house. I protested, but accused Balku also beat me. My mother died at the spot as she was beaten, struggling in pain. I orally reported the police regarding the incident. Police officer wrote the report and obtained my LTI there. Hudananda Gonda was the husband of my father's sister. He was present when I orally reported the police. He also signed in the report. This is the next page 39. The cross-examination. The house of the accused person about 200 meters away from my house. In between the house of accused person and mine, there are 4 houses. I do not remember now the names of owners of those 4 intervening houses. As I have left the place and residing in a different place. Udayoram and Manavadhuram live in one house. The incident took place in the evening time. I cannot give the exact time. All the neighbors were present and did not protest the beating by accused person. My Hamza, though the villagers are present at the spot, no one has examined me. The accused person also used brick beats to cause hurt to my brother. I invited the attention of my neighbors when the accused person pulled out my mother from my house, but nobody came to her rescue nor heard my request for help. Within half an hour, incident of beating was over. I cannot give the distance of police station from my house. My mother died at about 12 p.m. That is it. And
for the crime?
Motive for crime, my lord. The accused person that is the intention that this deceased was a witch. And he has killed her, their daughter of the Madhavanda. In this, that is the motive that as prosecution story. My homage submission is that except this
para 10 that is there. Let's come to page 40, para 10.
40, madam. It is a fact that the daughter of the Manavada died, and the accused person suspected my mother as witchcraft. Accused her applying with the craft. She killed the daughter of Manavodo, and for that reason, the accused person were not pulling on well with my mother.
Right.
That is it. I love the medical, the examination, the chemical examination report. That is the last page, 60. That is police sees the article that is blood deep, earth, sample earth, stick, mat. The opinion that there is no opinion. That is very important. While para 13 and 14 of judgment, I'm reading. Page 22 of the judgment. I'm reading the fact of it. The snatching the evidence of other witnesses, page 22. PW2 has deposed that he had put some signature in some papers being requested by the police. PW5 has deposed that he does not know anything about the case. PW7 is the Havildar who took the dead body of Puni Naik to the postmortem center. PW8 is the assistant surgeon who had collected the blood sample and the saliva from the accused person. PW9 is the investigation officer who sees some wearing appearance of the deceased and the blood stained earth and sent him for the chemical examination. The chemical examination report has marked as Exhibit 14. In this case, it is reported then that no opinion could be given about the blood splashes of the blood group sent to the forensic science laboratory. Therefore, the above evidence of the investigating officer is in no way helpful to the case of the prosecution. The second 14, madam, considerance as discussed above, the conclusion is therefore, I am driven to the conclusion that the prosecution has been able to prove the case of the murder of Puni Naik by accused person through the mouth of PW3. Beyond all reasonable doubt, there is no clear evidence as to which blow was responsible for causing the death of the Puni Naik. At this stage, the evidence of PW3 reveals that both the above named accused person assaulted. That is the question. Yet fair say that is difficult to say whose blow was responsible for the causing the death. And then and another says he has convicted both the accused person. How much? The doctor, the opinion of the doctor, that is it, PW6. Page 45. That on 1980, I was working as assistant surgeon in Pankos Hospital. On that date, the police question requisition, I conducted a postmortem examination. The dead body of the person whose name is not visible in the postmortem report, and found external injuries height and rolling down on a stony surface, except the exhibit marks of a village by successing fall. This is the case, but the other witnesses have denied the prosecution story and not supported the evidence. In this case, the judgment was passed. I think there is some correction required. Also his husband said it is very difficult to say whose assault this is the Puni Naik died. That is my information.
All right.
Yes, my lord, there's an eyewitness in this, my lord, PW3. There's a clear-cut motive in this. There's an extrajudicial confession before PW1. That is also there. And there's one PW1, and there is one immediate post-occurrence witness who is also related, of course, a related witness related to the deceased, who heard from the PW3 that her mother has been assaulted. She immediately comes out and sees the injuries, the body lying and the injuries on the body. And your lordship will see the kind of injuries, my lord, all bruises and lacerated injuries. But that is what the PW3 also says, that they have faced blows and kicks and breaks they have assaulted. So assault, that part has not been, well, that is admitted that these two brothers have come with a motive to assault the lady. They have dragged her out of the house, and the daughter is the sole eyewitness, my lord.
All right. Orders reserved.
Item 91, may I please? Lordship, the conducting counsel, Mr. B.S. Das Parida, is ill from viral fever, your lordship. Lordship.
All right. You see, stated that Mr. Parida led counsel for the appellant.
I'm excused. The personal appearance of the Balkuram may be excused.
Yeah. Now 90, you say the appellant is present in person. Then order is reserved. Correct. You say counsel, Mr. Paridal and counsel, the appellant stated to be unwell. List on 3rd November.
Obliged to Lordship.
Weekly list again. We have to get reports on the current status of many of them.
Yes.
They're not even appearing, no? You'll have to, instead of passing individual orders, I think you can just give instructions to all the IICs to give you information on the current status of each of the appellants. Because in that case, then we can appoint amicus curiae and all of that.
Yes, Mother will do it.
That's
In all the cases, we'll have to call for.
What happened to that item 1 that Rai Guru is not lifting his? Then in that first part, I think we'll appoint amicus curiae. Both have been released on bail, no?
Correct, what you said.
How many appellants we have to see? Yeah. Appoint.
This item 1, we have some instruction, my lord. That was in 2021, but I think latest report will show. They were all alive and staying peacefully in the village. But my lord, latest report, I think we should we'll call for my lords. Especially after the pandemic, my lord, I think we need to. The age. Judgment to give. The punishment coverage. Oh my lord. 55 appellants. No, 55 stood trial. Excellence. Only Subhas Goda, Gauri Jana, Sankajana, Devarajana. No,
2007, they were all released on bail.
Sankajana, Gauri Jana, Subhas Goda, and Devarajana. So, person following the office will do writing. $396. All good convicts.
none has been appearing for these appellants for over 4 weeks now. Although the appeal has remained continuously on board. Full stop. The IIC of the concerned police station is directed to serve upon notice is issued. You say notice is issued to each of the appellants through the IIC of the concerned police station, requiring them to remain present in court on the next date. In the meanwhile, a complete set of the paper book be handed over to the registry of this court by the registry of this court to the Secretary Orissa High Court Legal Services Committee (OHCLSC), who will assign to the appellants a counsel of not less than 10 years experience to appear and argue the case on their behalf on the next date. List in the will shift it to the hearing list, I mean miscellaneous list. Include in the supplementary list for 26th October. Next
item number 2.
Nine appellants. So what about 1-3? They were already released on bail, 2001 itself. Appellants 1 and 3 were enlarged on bail. In the first paragraph, he said none has been appearing for the appellants for several weeks now, despite the appeal being continuously on board. Appellants 1 and 3 were enlarged on bail on 19th April 2001, and the remaining appellants on 18 March 2010. Full stop. Paragraph. Notice is issued to the appellants to remain personally present in court on the next date. The notice be served on complete set of the paper book will be handed over by the registry. The Secretary OHCLSC, who in turn will hand it over to a counsel who should be assigned from the panel to appear for the appellants on the next date. We keep this for 2nd November.
Weekly list item number 5.
In the supplementary list. So this once it's reserved, you should remove it. Look from the list.
Item number 5.
No judgment, it looks like this one. This one's like this one.
He never appears. Of course. Kept on asking for time and now he's not appeared. The present appeal was adjourned at the request of Mr. Panda on 12th May 2022, 21st June 2022, again 11th August 2022, and 25th August 2022. Full stop. Thereafter, although the matter has been continuously shown in the list for the appellants. Full stop. In the circumstances. The SHO of the concerned police station is directed to again serve notice on each of the appellants, requiring them to be personally present in court on the next date. A complete set of the paper books be handed over by the registry of this court to the Secretary, Orissa High Court Legal Services Committee, for being interested to a panel counsel of not less than 10 years experience to appear for the appellants. We'll stop. The panel counsel will get in touch with the appellants well in advance of the next date. List on 9th November.
Weekly list item number 7.
7 she asked for time, right?
8. No, she's like asking for 8.
8.
7.
What is the position here in this matter? There are 2 appellants.
The last order of your lordship says 2010-2003. Prayer for bail is allowed as both the appellants were served the substantial part of sentence. Hence, release them on bail amounting to rupees 5,000 each. That was the last order, my lord.
These appellants were enlarged on bail on 21st October 2003. Although the appeal has been shown in list for over 6 weeks now, none has been appearing on their behalf. The IAC of the concerned police station will ensure notice is served to the appellants, requiring them to be personally present in court on the next date. Then repeat that whole thing. OHCLS. Listed for 10th November.
Item number 8.
Yeah, 8 onwards we'll call off for the next week. Up to this we stop because we don't want to take out all matter or